May I please, Lordship? Lordship, I beg to mention item number 26, my Lord.
26.
My Lord.
Why?
Well, it's because of inability of Mr. Saivala, my Lord, he could not come up today, my
Item 26. Who's for the petitioner? Any objection?
Yes, Your Lordship, I'll pray for a date, Your Lordship, since the petitioner is an age-old person. I pray let the matter be taken up on 2nd of April, Your Lordship. It's a Tuesday.
All right.
Readings are complete, Your
No,
Lordship.
no, not 2nd of April. Let it be on a motion day.
Uh,
We can have it on 3rd,
third.
3rd or 5th. 3rd April.
Yes, Your Lordship. Otherwise, Your Lordship, the
At the
readings are
request-
complete, Your Lordship.
At the request of learned counsel for the respondent, the matter be listed on 3rd of April.
3rd.
Mr. Dr. Learned R. Dr. Is it?
Yes,
Your name? A.
Yes.
Dr. Learned
AM Doctor.
AM Dr. Learned counsel for the petitioner. Submit the matter be listed on a fixed date based on 3rd April.
Third. Much obliged.
May I please, Your Lordship?
Yes.
We have filed one affidavit by respondent number 6 and 7 on 26. This is not a part of the record. May I call item 45.
45. All right.
Lordship, beg to mention for listing for pending writ petition, Lordship. Matter relates to pensionary benefits, Lordship. A date may be given.
You submit a mention memo.
Lordship.
Do you have a mention memo?
Yes, Your Lord.
You have it on 1st of April.
Lordship, April will be too late, Your Lord. On the last day, the Lordship, respondents didn't appear, Lordship. So,
All right,
Lordship,
13 March.
obliged.
My pleasure, Lordship. Lordship, I beg to mention item number 3. But in this matter, I have to supposed to take instruction, Lordship.
Mr. Chaudhary appears here.
My Lord.
He's appearing for that liquidator.
Yes, Lordship.
He's
In fact,
appearing.
not receipt, Lordship, maybe second of next week, Lordship.
No, but he's representing the liquidator. It is on behalf of liquidator we wanted you to
Yes,
obtain.
yes.
So let us see what the petitioner has to say.
Obliged.
May I please, Your Lordship, I beg to mention that item number 31, my lord.
31.
31.
Yes.
Matter may be passed for the may they my lord.
Item 31 at the request of your name,
B Das.
P. Das,
Yes.
for the petitioner.
No,
You are appearing for whom?
Isham.
Yes, for the petitioner. Is passed over. Item 31.
Yes.
Yes.
May I please, Your Lordship. Lordship, I beg to mention item number 29, Lordship. Can we adjourn the matter, Lordship, for a day? I have
You are
taken-
mentioning on behalf of petitioner.
Yes, Lordship.
Any objections, state respondents?
I have taken consent from other side, Lordship.
Item 29 be adjourned and listed after 2 weeks.
May I please, Your Lordship, by the last order, Lordship, I was directed to take instructions in the matter. Lordship, if I may just point out, Lordship, except for the petitioner number 1, the others are perhaps outside the purview of this High Court. And
Not only
Now-
one, my lord.
now, if I may complete. Now, Lordship, they are posted in Chhattisgarh, all of them. I have received some instruction, Lordship. This is not very clear and it's in Hindi,
They are all posted,
in Chhattisgarh, yes.
all, including the petitioner.
Yes. But petitioner being an Assamese may have a cause of action here.
Where were the appointments made? Where did they appear for the appointment?
Appointments, rest are not in Assam.
My lord, all the petitioners appointed in the year 1994, my lord.
Where, from where?
From Assam, my lord. So all are not from Assam. Some of the petitioners from Assam, my lord.
Who are the petitioners? No,
My
it's
lord,
not from Assam or anything. It's a question of you have to show us that the cause of action arises within the.
my lord,
jurisdiction
actually,
of-
cause of action regarding salary, my lord.
First,
salary,
you have to tell us where the advertisement was there, where did they apply, where did the interview take place?
my lord, in this regard, I have not annexed any document, my lord. Because
Anyway,
In any case, Lordship, this instructions.
are awaited.
Are awaited. I have to get it from Chhattisgarh,
All
Lordship.
right.
So some more time may be given.
We'll give him some more time. Meanwhile, you also gather your instructions. At the request of Mr. Architect Chaudhary Leonard, he is here in Western for 3 weeks, enabling him to complete his instruction. Mr. M. Soya, Learned Council, appears for the writ petition. Please stop to 3 weeks.
So, Lordship.
my lord, tell it, fix a date, my lord.
Fix a date on let it be on 8th of April.
So,
May I please? But the matter relates to the pensionary delegates, my lord. On last version, it was directed to the inspection by PNRD, my lord.
May I please your lordship? Lordship, we have not received the instruction, your lordship. Lordship, kindly sometimes may be given.
His service book has been reconstructed.
Lordship, they have mentioned that in the petition they have mentioning, but we have not received the instruction, your lordship.
Or you get instructions,
Lordship, lordship sometimes may be given it.
2 weeks further time,
Lordship,
Definitely.
2 weeks further time granted to the Learned Council, MS so appearing for the respondents to complete the instruction. As it is submitted that the respondents are not posted with the instruction, Mr. Islam appears for the writ petitioner based on 22nd March.
Bless.
22nd.
oblige your lordship.
Yes, tell us.
Lordship, the petitioner was appointed as semi-skilled workman. at
Your
last-
grievance is with regard to non-payment of your wages or
Lordship.
salary,
Lordship,
and that is by the respondent number 3,
Lordship,
who is appointed as a liquidator.
Lordship.
Now, against this, your remedy lies before the NCLT.
Lordship,
Company is already in liquidation.
Lordship, kindly look into Annex 8, page 40, Lordship.
Page,
Submit curriculum.
Huh?
Page number?
Submit curriculum. Okay, only until
yes.
Lordship, we have submitted the claim, Lordship, and Lordship, Annex 8 is a repeat.
then also, my lord, NCLT is the proper adjudicating authority.
Who appointed the liquidator?
NCLT, my
Lordship.
Then it is on applications made before NCLT or winding up. I think NCLT Delhi.
NCLT Delhi.
So your proper forum is the NCLT. You have to, you have approached the liquidator relying on the orders of the industrial tribunal. The liquidator has refused, rejected. Yes. So against that, your forum lies before NCLT. Unless you can satisfy us that, notwithstanding that, the writ court can exercise jurisdiction. That was the reason why the matter was deferred.
Lordship, the matter may be adjourned for today, Lordship, but senior will satisfy this.
We have given you, that would be the last opportunity. Please inform your senior.
Lordship,
Otherwise, we are dismissing your petition.
Lordship,
Heard Learned Council to depart.
Lordship.
This writ petition is filed by the petitioner aggrieved by rejection of his prayer for release of what, salary or wages? for his service dues. Rejecting his service dues. Claim for service dues by the sole liquidator, namely respondent number 3, who was appointed for the purposes of liquidation of his erstwhile employer, namely Hindustan Paper Corporation. Which paper mill is that? Jagirod.
Kasar.
Kachar.
Under Hindustan Paper Corporation.
Mr. P. Chaudhary, Learned Counsel, appears on behalf of respondent number 3, who submits that this writ petition is not maintainable, as the proper forum would be the NCLT.
Adjudicating authority.
Adjudicating authority would be the NCLT, and the petitioner is required to approach the NCLT for redressal of his grievances. MSR Devi appears for respondent number 1. 1 and 2. 1 and 2. Learned Counsel for the petitioner submits that the matter be taken up on some other date, enabling him to satisfy the court that the court can exercise jurisdiction under 226, notwithstanding the objections raised by the counsel for respondent 3. List the matter again.
The petitioner may be directed to furnish a copy.
Yes. List this matter again on 13.5, 13.3. The writ petitioner, meanwhile, will furnish a copy, sufficient copies of the writ petition to the standing counsels appearing for the respondents to enable them to complete their instructions before the next date fixed. Yes.
The petition is against non-granting me regular pension by the State Bank of India. Now, they don't have a standing counsel, so we couldn't serve the copies. I'm praying for a notice.
They say you are not entitled.
They say I'm not entitled, but this honorable court says that you pay the superannuation dues in light of the dismissal order.
Where is the dismissal order?
The dismissal order, your lordship will find. At page 21. This is the order of dismissal. Para 3. Remove from service with superannuation benefits, pension and or provident fund and gratuity as would be due otherwise under the rules and regulations.
As would be due.
My lord.
Subject means subject to
My lord,
being available.
my lord, my case is, my lord, I was placed under suspension and finally this dismissal order comes.
How
My
long
lord.
did you put in service?
My lord,
How many years did you put in service?
19 years till the date of my suspension. From my suspension till the date of my dismissal, it takes 1 year, 2 months. my lord. They pay my substance allowance. Now, by the order of dismissal, they say that you will not be treated as on duty. Now, this totaling all these years, my lord, I crossed 20.
Okay, heard counsel for the party, for the petitioner. Petitioner is aggrieved by non-release of his retiral dues pursuant to his dismissal from service by the disciplinary authority upon a disciplinary inquiry instituted against him. So, learned counsel for the petitioner refers to the order of dismissal at Annexure 4 of the writ petition, which says that the order of dismissal and the order of dismissal reads as under. Quote the whole portion. So, learned counsel for the petitioner submits that the disciplinary proceeding was put to challenge in an earlier round of litigation, being WPC 4939 of 2010, and by judgment dated 2002-2018, the writ petition was dismissed with the observation that the respondents will ensure all superannuation dues to be disbursed to the petitioner in terms of the impugned order dated 26/5/2009. Stop. It is the submission of the learned counsel for the petitioner that pursuant to the judgment and order dated so and so, passed in WPC so and so. When the writ petitioner approached the authority for release of his superannuation dues, the same was rejected by order dated by communication dated 5/7.
My lord, this is 23/8/2018,
Where is that?
page 33, my
By communication dated 23/08/2018, within bracket annexure 9. Stop. The chief manager SBI held informed the petitioner that he was not eligible for pension as he had not completed 20 years of pensionable service. Para. It is also informed that the SBI does not have any standing counsel. Accordingly, let notice be issued, written for 4 weeks. Steps on respondents by usual course as well as by registered post ED. You want to take Dusty?
My lord, he won't be given it.
Matter be listed after the returnable date.
Apply.
So kindly pass the body matter for time being.
Time being. Yes, time being.
Matter pertains to non-payment of provisional family pension and provisional gratuity. As per my lord office memorandum dated my lord 14 June 2016. The husband of the petitioner my lord serving as a my lord head teacher of the my lord Tilbury High School, and he died during the course of service. And as his post was provincialized with effect from 1/1/2013, the service my lord fall under the NPS. As per my lord office memorandum, my lord, the government decided to pay the provisional family pension. My lord,
Where is that?
my lord kindly see page 25, my lord,
25.
Annex 6. Therefore, Governor of Assam is pleased to extend the following additional benefit to the state government servant coming within the purview of NPS, appointed on or after getting discharge on invalid and disability, or families of such employees covered by NPS have died in harness with a view to mitigating hardship meted out to them or to their families in the line of government of India on provisional basis until further orders, when the rules regulating these benefits under NPS are sent. As per this notification, my lord, memorandum, the petitioner entitled provisional family pension. And now, my lord, kindly see, my lord, page 43, my lord. It is another office memorandum, my lord. The government, my lord, decided
No,
to
where is the, from which part of the memorandum you say that it is payable? Show us the particular paragraph.
my lord, page 26, my lord.
26.
I copy, my lord.
Mhm.
Therefore, Governor of Assam is placed to extend the following additional benefit to the state government servant coming within the purview of NPS, appointed on or after 1/2/2005 on getting discharged on invalid disability pension. Number 5(1), retirement from government service on invalidation not attributable government duty. And second, death in service not attributable to the government duty. And 5, Roman 3, discharge from government service due to disease, injury, and so and so.
So these are additional benefits.
Additional benefit.
And what happened to the petitioner's husband?
Husband my lord serving as a my lord head teacher of the Tilbury High School, and kindly see my lord
He expired during service.
during service, my lord.
So clause number 5(2).
2, my lord. And second, my lord, another office memorandum, kindly see my lord, page 43.
Clause number 5(4), I think, or 5(2).
4, my lord.
Attributable to government duty. So it will be 5(2).
5(2), my lord.
Then
Family pension computed in terms of 140, Rule 140 and Rule 143 of Assam Service Pension Rules.
And DCRT.
DCRG.
Right.
And regarding DCRG, another government issued my lord kindly see page 43.
Yes.
Extension of benefit of retirement gratuity and death gratuity to the state government employees covered by new defined contribution pension system regarding. As per two office memorandum, my lord, the petitioner entitled the provisional family pension as well as provisional gratuity, my lord. Therefore, the petitioner filed a representation, my lord, on page 49. And on similar circumstances, my lord, this honorable also passed the order, my lord, directing the Director of Accounts and Treasury, my lord, to pay the provisional pension and provisional gratuity. My lord, kindly see page 45, Annex 10. Portion page 48.
Hmm.
Petitioner seeking the same relief, my lord.
Yes, who's for the respondents?
PTC, my lord, mainly PTC, my lord.
TTC.
Lordship will issue notice at this.
He is asking for similar relief. What is the difficulty? You examine.
No, let us, no, that is their lordship. What is that? Lordship, look at page 26, lordship.
26.
Page 26 in that paragraph, lordship will kindly see the last line. Only until further orders when the rules regulating these benefits under NPS are framed and enforceable. Lordship, I have to take status of this notification of 2016. If it is there, definitely same benefit will be granted to the petitioner, lordship. Otherwise, lordship,
So that is what we do and dispose it of. If he is asking for that only,
lordship will, authority will verify and
verify his claims under this notification, and if
Lots.
applicable, will release.
Lordship.
Okay.
Okay.
Dispose.
Outline.
Number given to you.
My lord, here, my lord. Here I appear for respondent 3, 4 and 9, my lord.
Mr. Borpuzari appears for
My lord, respondent 3, 4 and 9,
3, 4 and 9.
my lord.
Mr. Nayok
I'm for 6 and 7, lord.
6 and 7. Mr. T. Soikia for
2, my
for 2. Anyone else?
Education.
Education Council, Terang P appears for 1
lord.
and 4.
I am for 5, my lord. I'm sorry, my lord. 3, 5 and 9.
5 and 9.
Right.
Mr. Borpuzari disposed.
Outline.
Well, matter particular non-payment of pension value with effect from the date.
Non-payment of
Pension value. Well, earlier, well, it was sanction value, but subsequently, well, take positive was issued. Well, here in this case, well, whatever, well, petitioner had rejected from service on.
Oh, what is minor psychiatric disorder?
Well, what happened, well, actually, there should not be cause, well, because during his service, she was okay, well. After retirement, well, actually, it was on the income, not the part of the
No, I want to know what is the meaning of minor psychiatric disorder.
Minor, that is not actually, well, something, well, imbalance type, well.
More commonly known as depression.
Depression, well.
Depression.
Well, now, well, initially it was sanctioned, well, but subsequently, well, a original, well, can you see, well, page 28, well.
28.
Well, it was sanctioned, well, pension, well. Yeah, my lord, I am with effect from my lord. Can you see? With effect, that effect was given, my lord. 1/4/2021, my lord. That was rightly done, my lord. Because petitioner retired from service on 31/3/2001, my lord. Whatever, my lord, thereafter, my lord, certainly, my lord, a corrigendum was issued, my lord, page 30, my lord.
Then
Page 30, my lord. This is the corrigendum, my lord, against which the my lord petitioner is aggrieved, my lord. That effect was given only with effect from my lord 9/10/2019, my lord.
according to you, it should be
1/4/2001, my lord. Immediately after the date of retirement,
1/4/2001.
my lord.
And here it is given up to from 19.
19, my lord.
Why was it given like that?
My lord, because the pension paper, my lord, was submitted lately, my lord.
Yes, respondents, anything, any comments?
My lord, in this matter, notice may be issued, my lord, during it. Because my lord,
Heard
there's
counsel for
possibility
parties of this in 4 weeks. Mr. P. Soikia is for
Respond number 2 and 5, my lord.
respondents 2 and 5.
My lord.
1, 3 and 4.
1, 2 and 5.
I appear for all speak, my lord.
H. Terangi appears for respondent 1, 3 and 4. Mr. Pujari 4. Respondent 6.
6, my lord.
6. Since learned standing counsels appear, the opposite respondent notices of it, our extra copy will be furnished within 1 week from today. This after returning.
Obliged, my lord.
He has a very interesting name. Name of the petitioner. Yes.
I don't, annexure to page 10, my lord. I did. It is letter written and superintendent, my lord, on 28/5/18. With the reference to subject headed above, I have to honor to forward herewith a praying petition received from the Tukil Khan, retired grateful employee of Central Madrasa, who is retired from 39/17, is praying for me, Lord. The Central GPA final and NRA authority. It's at least 11, my lord. This letter written before my retirement, prior to retirement, it is non-refundable amount that is due, my lord, 22,500. And another is, my lord, is 4, 12 annexure 4. It is 1,17,340. Altogether, my lord, Lordship will find, my lord, annexure 5 and annexure 6 by last non-payment certificate issued, my lord, by the headmaster. That NRA authority, it is 22,000 and this amount. So I am before this court, my lord, for releasing of this amount, which admitted it due to me, my lord. And
Yes, get your instructions. Why? Who's appearing here? Secondary education.
Yes, my lord. And main, my lord, accountant general, may the concern, my lord, respondent number 4.
What is seems to be the problem? Any
Lordship, have to take instruction.
instructions? Get your instructions.
Yes,
here.
my lord.
Heard learned counsel for parties. Let the matter be listed after 2 weeks
For motion, my lord.
for motion, enabling the learned standing counsel for accountant general, Mr. B. Chakraborty, MS H. Terangvi for secondary education department, and Mr. Borpujari for treasury officer obtain their required instructions in the matter as to why the GPFN
My lord, non-refundable advance, NRA.
non-refundable advance. What is that?
non-refundable advance, NRA authority, it is. NRA.
Why the dues claimed by the writ petitioner have not been released in spite of repeated requests made? In order to facilitate the standing councils to obtain their instructions,
Yes.
extra copies be
Yes,
furnished within
definitely.
1 week from today. After 2
Yep, yep.
weeks. For motion. Yes.
May I plead your lordship? Lordship, the petitioner is aggrieved by non-payment of the provisional pension.
Provisional pension.
Provisional pension.
Yes.
The petitioner was arrested in the year 2021, into some criminal case, and thereafter he was released on bail, and in the meantime, suspension order was issued under 6(2). And thereafter, in the meantime, he retired on 28/2/2022 during the period of suspension. On 28/2/2022, he retired, but no provisional pension has been paid yet. In the criminal case, charge sheet has been filed and the trial is
Yes.
going.
Any instructions?
Lordship, the thing is that Lordship, until anything very adverse, Lordship, until anything very adverse against him, payment of this pension, Lordship, provisional pension during the period of suspension, that is Lordship very honest. Let me get the instruction. And second thing is, Lordship, the DP perhaps it is will be pending, Lordship.
You get your instructions, heard learned counsel for the parties. The petitioner is aggrieved by non-release of his provisional pension.
Provisional pension. During the period of his suspension.
Which he is otherwise entitled to. The petitioner has represented before the authorities, but no response has been received from the authorities concerned. Better let the respondents obtain their instruction. Let the respondents complete their instructions in response to the claims made by the writ petitioner. Mr. PKS Borua appears for
1, 2, 4, and 5, Lordship.
1, 2, 4, and 5.
Please.
4 and 5. Accountant General,
Secretary.
Ms. K. Das for Accountant General. In order to facilitate the respondents, standing councils to complete their instructions, extra copies be furnished within 1 week from today. Let the matter be listed after 2 weeks.
Please, your lordship. In this case, lordship, instruction is sought for lordship. Standing council, lordship.
Perhaps Lordship have to may pass the appropriate order, Lordship, in this case, subject to my friends, Lordship.
We have already received the pension, but some amount has not been paid. So actual amount of pension and gratuity, I have not been paid, lordship.
Yes.
Lordship may dispose of the case, Lordship, directing the authorities to examine the case of the petitioner, Lordship.
Lordship,
So examine and not just examine in the light of the judgment of Sanjita Roy.
Lordship.
Honorable Court already held, lordship. The further exercise is not.
What is this office memorandum at page 52?
Page, lordship.
Annexure G.
Annexure G. That is, lordship, this office memorandum also states that the master roll workers during the period of master roll period, that should not, that should also be counted. It is, lordship, as at page 52, last part.
For calculation of pension.
Calculation of pension. Last part, lordship. 52 page as regards pensionary benefit to regularized officer. Master rule period of regularized workers should also be counted. Master rule period should also be counted for the purpose of allowing him her pensionary benefit. That memorandum is contradict the earlier memorandum, Lordship. That is, I have already annexed, and it is as per the Honorable Court's judgment, Lordship, this memorandum is, Lordship. But the authority has not given the actual benefit on the basis of that memorandum.
I heard learned counsel for the parties. This writ petition is filed by the petitioner who served as a master role worker under the Executive Engineer Dhubri Division Irrigation, Gauripur. Stop. He was appointed on 1/7/1992. When was the initial appointment? 1/7/1992.
92, Lordship.
And he was regularized as a helper with effect from 22/7/2005 by order dated 6/10/2005. Stop. After rendering his services, he retired from service with effect from 31/12/2022 on superannuation. When the pension papers were prepared, the gross period of service was shown as 29 years, 9 months. And the net qualifying service was shown as 23 years, 9 months. Stop. The last pay of the petitioner was reflected as 27,190. Stop. On this basis, the pension was calculated, and according to the petitioner, the amount of pension that he has received is less than the amount he's entitled to receive under the provision of law. It is submitted that his initial years of 6 years was deducted while calculating the period of service and arriving at the amount of pension payable to the writ petitioner. Stop. Learned counsel to the petitioner submits that this deduction of initial of years of 6 years, initial period of service of 6 years has been held to be contrary to law by a judgment of this court reported in so-and-so Sanjita Roy. And that apart, by office memorandum dated 31st of July 2010, the government of Assam issued an office memorandum whereby it was provided that part of their past master role services prior to regularization are to be counted for the purposes of pension in terms of PPG department's OM number so-and-so dated so-and-so page number 52. Para. The respondents were permitted to obtain their instructions, however. No such instructions have been placed before the court as on date. So, considering the limited prayer before the petitioner before this court, and upon careful perusal of the writ petition, as well as the judgment dated, enclosing the judgment dated so-and-so passed in WPC so-and-so, it is seen that the coordinate bench has categorically held that the deduction of 6 years or for that matter any period to calculate the 20 years of continuous service is unreasonable, and the said deduction was held to be bad. Stop. This judgment was further upheld in a writ appeal, being writ appeal number 18 of 2021, within bracket Binapani Das, others. Binapani Das versus State of Assam and others. Stop. The division bench of this court, by judgment and order dated 26/2 2021 passed in writ appeal number 18 of 2021, upheld the findings of the coordinate bench of this court rendered in Sanjita Roy. So, in view of that matter, the issues raised in the writ petition appear to be covered, are covered by the judgment and order dated so and so Sanjita Roy, as well as in writ appeal number so and so Pinapani. Pinapani Das. Stop. In that view of the matter, the writ petition stands closed with a direction to the respondent authorities to examine the claims of the writ petitioner, and if found to be correct, then the benefit, then the deduction of 6 years, as was done from deduction of 6 years of service, as was done in the case of the petitioner, to calculate his continuous period of service and to arrive at the amount of pensionable amount payable to the petitioner be re-evaluated, and the appropriate amount payable to the petitioner, taking into consideration his entire period of service, as have been held in the judgments dated so and so, be released to the petitioner without further delay. The entire exercise be completed within a period of 60 days from the date of receipt of a certified copy of this order.
Pension and gratuity also, Lord.
Pension, gratuity, and all other retirement benefits. The Mr. Upadhyay appeals
1, 4, and 5, Lord.
1, 4, and 5. Mr. CKS Burua 4. 4.
Respond number 3.
3. Mr. Borpuzari 4.
R2, madam.
R2. And Accountant General
Nobody is here.
MS J Das for Accountant General. Hold that. Yes.
I may appeal, Lord. After prolonged 9 years of suspension, my lord, and the respondent authority did not pay any
Suspension on 2014, Lordship. Now the petition has approached this honorable court. No reparation, nothing, Lord.
As a petitioner filed appeal, my lord, case 111, my lord. That was not considered, my lord. That of subsequently, my lord, 2023, my lord, case 117, petitioner filed a representation, my lord. And in the meantime, my lord, petitioner attained the age of superannuation, my lord, 31st/10/2023, my lord. A DP is pending, my lord.
DP is pending.
Yes, my lord.
Now, what is your prayer here?
My lord, in this case, my lord, suspension order may be set aside and reinstated.
How does it, you're superannuated?
My lord, petitioner already in superannuation, my
then-
lord. Retired on service, my lord.
Then
He has not paid any subsistence
your
allowance, my lord.
subsistence allowance can be directed to be released.
Yes.
If not released,
Yes, in the meantime, the respondent authority may complete the departmental proceeding, my lord.
that is all right, but
Right.
we cannot pass any orders for cancellation of
Yes, yes.
suspension order. It is
My lord,
irrelevant.
yes.
Delay part, Lordship, approaching the court, Lordship, it is not in.
Oh, delay, it is a continuing, for him it is a violation of his rights. You are putting him in suspension for how many years?
9 years, my lord.
Why?
My lord, as per instruction, my lord, inquiry has been completed, my lord. Inquiry has been completed in this case, my lord. Now, for imposing for penalty, my lord, the view of the APC department has been sought for, my lord. Now it is under process,
No, but why did you keep him under suspension for 9 years?
my lord. The inquiry process is completed for long time, my lord.
Your clients are probably not aware that suspension is not a punishment. They're thinking it, they're using it like a punishment.
And notice may be issued, my lord.
No, we are disposing it off. He has a representation pending. You look into it, release all his
Appeal is also pending, my lord.
Appeal is also pending.
Yes, my lord. Case 111, my lord.
Appeal is meaningless now. You're retired.
Yes, yes.
Inquiry by the board has been completed, my lord. His, found, inquiry by the board is completed, my lord.
You
His file-
complete. We are not saying anything about the inquiry. You complete it. Whatever, if you want to impose any punishment, impose it.
Yes.
But his subsistence allowance,
Yes.
if not otherwise held, if there is no finding in the by the authority, it should be released. Heard learned counsel for the parties. This writ petition is filed with the petitioner, who claims to have been put under suspension with effect from
Page 111, my lord. 25/8/2014. 110.
25.
25/8/2014.
Your application says it is 4.
No, my lord. The application is page 100.
Where is the order of suspension?
Page 110.
Suspended with effect from 25/8/2014. While you were serving as you are which? This number 2.
Assistant Executive Engineer.
In page number 110, you are at serial number 2.
Yes, my lord. Yasuddin Ahmed.
Serving as Assistant Executive Engineer, Sonapur Subdivision Irrigation under Guwahati Division Irrigation. Stop. It is the submission of the learned counsel to the petitioner. Being aggrieved, he had filed an appeal before the competent authority, namely the Secretary Government of Assam Irrigation Department, by appeal dated 27/6/2018. However, the same remained pending and no orders have been passed. Learned counsel for the petitioner submits that since his date of suspension, which is 25/8/2014, the petitioner has been kept under suspension and no subsistence allowance has been paid. And the departmental proceedings, although initiated, have not been completed against the petitioner. However, in the meantime, he has superannuated on
My lord, 31/10/23.
2023. Stop. Although in the writ petition, the petitioner prayed for setting aside of the suspension order, praying for inter alia, setting aside of the suspension order. However, in view of the statement made that the petitioner has superannuated with effect from 31/10/2023, this prayer need not be, this prayer has become infructuous. Stop. Para. MS Neog, learned counsel appearing for Irrigation Department, on instruction, submits that the inquiry instituted against the writ petitioner has been completed, inquiry report submitted, and the matter is presently pending before the APSC.
Yeah.
APSC for their views. And once the views are received, appropriate orders will be passed by the disciplinary authority. Stop. Taking into account the submissions made by the learned counsel for the parties, and also taking note of representation stated to have been filed by the writ petitioner dated 17/8/2023, and which is also stated to be pending before the Secretary Government of Assam Irrigation Department, Dispur, Guwahati 6, this court is of the view that since the petitioner has superannuated with effect from so and so date, the prayer for interference of the suspension order need not be issued. However, the petitioner is entitled to be paid all his subsistence allowance as per procedure prescribed under law. if that amount has not already been released. Stop. Taking into consideration the submissions of the respondent counsel that disciplinary proceedings have also been completed and the inquiry report having been submitted, and the matter is awaiting approval of the views of the APSC, pursuant to which orders will be passed by the disciplinary authority. It is expected that the disciplinary authority will, it is expected that the APSC will render its views at its earliest, and thereafter the disciplinary authority will pass necessary orders on the basis of the inquiry report stated to have been submitted by the inquiry officer, and a copy thereof be furnished to the writ petitioner. Stop. This entire exercise be completed by within a period of 60 days from the date of receipt of a certified copy of this order. Stop. The direction for release of subsistence allowance and other dues payable to the petitioner during his period of suspension be carried out within 15 days from the date of receipt of a certified copy of this order. Writ petition accordingly stands disposed of in terms of the above.
All right. Back to copy to the board.
Your Lordship. My lord, in this case, my lord, before taking to the annexes of this application, my lord, here in this case, my lord, the petitioners agreed, my lord, the suspension order that is 16 to 2024. Here in this case, I was suspended only on the basis of the renewable inquiry conducted, my lord, as per report 13 to 24, my lord, on the verbal instruction from the respondent number 5, my lord, and that report, my lord, absolutely the replica of the earlier inquiry conducted by the respondent number 5, who instructed the authority to de novo inquiry, my lord, that I have enclosed it annexure 3, my lord, absolutely the same set of allegations, my lord, report, and moreover, my lord, that inquiry report, I'd like to take your lordship kind attention, please to it in annexure 3, the first one, that is 24/7/2023, my lord.
Yes.
Yes, this is a report done by the respondent number 5, inspector of school, my lord. More particularly, my lord, annexure, serial number 4 and 5. But I will read from top. As per the complaint received from the president.
Page number?
28, 28, my lord. Annexure 3.
Yes.
Yes. As per the complaint received from the president and member SMDC, this is respondent number 7 here, my lord. Balikuri Anshalik High School on 9/6/23. We, the undersigned, had visited the so-and-so high school on 28/6/23 at 1:05 p.m. regarding various allegations against the in-charge headmaster of the state school. And accordingly, we have in fact found the following. Number 1, my lord. The IC headmaster was served very poor and less MDM to the students as per written statement of the students president member so-and-so. Number 2. The IC headmaster was not served 8 on the Wednesday as per the schedule and deprived the students from the empty Saturday as per the written statement of students. Number 3, my lord. As per the written statement of the student, it is mentioned that headmaster was given different types of fare and clothes. Number 4 and 5 and 6, my lord. As per the allegations, the headmaster was collected the rice from the Somabai on 15 March 2025, 15/3/23, but the rice was not taken in the stock from room, and he was written on stock register on 11.72 kg rice was received. The MDM was not served in the month of March, March 2023, due to examination. Number 5, my lord. As allegation, the stock register MDM scheme shown that the opening balance of rice so on the main 23, and the rice was against receipt of 1 quintal on the same month. The total balance of so kg.
So what happened after this?
After, my lord, page 29, next page, annexure 4, I have been asked for hearing, my lord, by the deputy director.
Then
6/10/23. Then, my lord, on that occasion, I appeared and my lord, page 30, this is my reply before the authority, my lord.
All right.
In my reply, I elaborately, my lord, replied all the questions raised in that inquiry report. Then, my lord, this hearing, no findings, my lord. It is still it's lying before the authority. Then, my lord, annexure 10, my lord, some one Abdul Quddus One, Abdul Quddus, yes, my lord, filed a writ petition before this honorable court, Annexure 10, page 54, challenging the, my lord, appointment of the private respondent number 7 as the SMDC president, since he's having some criminal background. Therefore, my lord, he is not eligible for the post, holding the post of SMC. Then this honorable court interfered and certain observation made, which is also in favor of the present petitioner, my lord. Page 56 is the order. 20 to 124, my lord. I'll take your lordship the relevant portion, my lord. Page 57 onwards. The petitioner has, by when instituting the present writ petition, raised the grievance with regard to the selection and appointment of the respondent number 6 as the president of the School Managing Development SMDC Valikuri Soencho. It is submission of the learned counsel for the petitioner that the said respondent 6 is not suitable person for the being appointed as the president of the SMDC school in question, inasmuch as there is a criminal case pending against him being Borpeta PSK Soencho, wherein after investigation, the investigation officer has already submitted a charge sheet before the Honorable Chief Judicial Magistrate Borpeta, and said matter is stated to be pending trial as well. Now, next paragraph, my lord. The petitioner also, by drawing the attention of the various representation made by the headmaster, that is present petitioner, my lord, of the school in question, and also other have stated that due to inaction on the part of the respondent number 6, the students of the school in question are suffering on account of not being able to have access to the midday meal scheme. In this connection, the learned counsel for petition has drawn my attention to the representation made by certain individuals before the Director of Secondary Education, highlighting the illegalities committed by the respondent number 6 and conjugal difficulties faced by the students of the school in question. The said represent stated to be heading. In view of the above, the petitioner Soencho is required to file a detailed representation highlighting the illegalities and irregularities in the appointment of the respondent number 6 as the president of Soencho school in question, along with the conjugal difficulties faced by his and wards.
Now you are aggrieved by what order?
Yes, my lord. Then, my lord, after this order, my lord, this matter was discussed before the local MLA, before the Legislative Assembly, my lord, and that wherein he raised question that instead the government authority, instead of taking action against the headmaster of
So
the
you are
concerned-
placed under suspension at page 61.
My lord, before that, my lord, this inquiry report. Annexure 11 page.
All right. But
Yes,
you are
I
aggrieved,
agree
you
on
are
this
aggrieved by page 61.
Yes.
You are aggrieved by page 61.
11 also, my lord. Yeah, page 60 also, my lord. On the
60
basis
also.
of this report, I am suspended. Annexure 11, page 60, my lord.
Who has given this report?
My lord,
Block accountant.
yeah. My lord, from above, from top, as per the verbal instruction, my lord, kindly, my lord, note it. As per the verbal instruction of the in-charge inspector of school, my lord, that is respondent number, who has already conducted inquiry, the Annexure 3 lordship thus have seen, my lord, on his verbal instruction, my lord, to understand these 4 persons, my lord, block account, district account officer, senior account officer, PSO is office, my lord, they conducted this inquiry. Lordship will find serial number 6 and 7.
So let the respondents.
Now,
come
my
up.
lord, my question is here, my lord. Your lordship, kindly, my lord, here honorable apex court cite us on this point, my lord. Since you are taking action, de novo inquiry you have conducted, since you have to place the latest information, latest fact, latest inquiry, whatever you have found illegally against delinquent officials, my lord. But instead of doing so, you have relied on earlier reports, my lord. Relying on earlier reports, you have conducted de novo inquiry, but relying on the earlier report, which is not at all permissible. My lord, this is the honorable apex court, my lord. Kindly, I may be allowed paragraph 14 of this.
No, but we will look into all this. We are saying that right now you are aggrieved by the suspension order
My lord, first of all, my
on
lord,
the basis of this inquiry report.
absolutely. My lord,
Right.
that earlier inquiry report, I
But-
have
but-
participated. It is
but,
not yet, my lord, passed any speaking order on that.
May not be, but immediately on this date, we can't grant you an interim order to suspend the suspension order. We'll issue notice. We are not rejecting your interim prayer. We'd like to hear the respondents, what they have to say regarding this.
My lord, normally, my lord, had it been in the de novo inquiry, my lord, they are genuinely following the law guidelines. They have placed me suspect. I would not have approached before this court. I am aggrieved, my lord. Since
Kindly see,
my lord,
kindly see page 61,
my lord. Yes, my lord.
5th paragraph.
Yes, my lord. Now, pending trial of department
Pending trial of departmental proceedings.
is here placed under suspension. But my lord, this itself, this suspension order they followed, my lord. Already they're relying on de novo inquiry, where de novo inquiry, all the report based on earlier report, my lord.
Maybe, but this is a suspension order which is
This is not
pending drawing of departmental proceedings. You are entitled to challenge it. We are not saying that you can't challenge it. But today on prima facie on this, we don't find anything wrong with the suspension order. For instance, is issued by the director. Who is your employer? Who is the higher authority?
my lord.
They have made certain allegations here. These allegations on the face of it, without giving an opportunity to the respondents to
Absolutely,
respond.
Lordship, we give absolute opportunity,
Correct.
my lord. I am thus agreed, my lord. Why they have, my lord, stated that they have conducted de novo inquiry, my lord. Despite de novo inquiry they have conducted, but why they have read the earlier inquiry report, my lord? That is
we will-
2022 July report, my lord.
We will issue notice.
Well, certain observation made so that they could intermittently let them file affidavit. my lord.
Whatever they want to do, why observations are not necessary, we'll issue notice as well as notice on the interim prayer.
My lord.
And let them respond something,
Yes.
we'll decide on
I'll
this.
leave it up to lordship. Yes.
Because unless you show us that it is not as per rules or it is an infraction of the rules, prima facie, we would not like to. On what basis are we interfering with the
My lord, wait.
suspension order?
Since lordship has thus seen, my lord, the two, if lordship compared both the reports, my lord, it is same, my lord. Even, my lord, whether on the verbal instruction, inquiry can be conducted, my lord, only relying on.
That is a different issue. Verbal instructions, what the records reveal, we don't know. Maybe on the next date, if they produce the records, we may like to accept your submission
My lord.
and interfere with the suspension order. But the suspension order reveals some
I
inquiry
understand, my lord.
report.
I understand what lordship proposing me. Yes, I
It doesn't talk about, or let us say the inquiry was conducted by the director herself, or she's not otherwise authorized, or she had already relieved office on the day when the order was passed. In spite of that, some order was passed,
my lord.
or the provisions of the rules are not properly followed. You are aggrieved by technically by the order of putting you under suspension,
My lord.
and the inquiry on the basis of which the suspension is stated to be issued. So we need some response from them. What interim orders do you have?
Our entry prayer, my lord, at page 24. It is possibly prayed that till disposal of
You
the
are
case.
asking for stay.
Yes, I'm praying for stay of this suspension order. See. Had it been
Stay.
delayed on the de novo report, inquiry report, I would not have approached before this honorable court. But I'm agreed, my lord, absolutely relying on earlier report, which is pending, my lord, not yet considered by that report. My reply is also pending. Huh? Huh? Oh, my lord, lordship, if lordship permits only one annexure, I have to draw your lordship kind attention, my lord. Yes. My lord, page 28, annexure 3, the first inquiry report. This is allegation number 5, my lord. So for I'm considering allegation 5 in the last two line, my lord. But when, as per undersigned, was visited the school on 28/6/23, it was seen that only 20 to 25 kg rice was available. That means in the June month, only this rice is available, whereas closing balance shown that 2 quintal 11 kilos. Lordship, kindly have a look at Annex 7. Just lordship. Annex 7, page 42, and the operative portion at page 45. That's what the allegation below.
Yes.
Here, lordship will find the opening balance 211,800 as per the allegations below. Lordship will find, my lord. They, instead of counting all this, my lord, they visited on 26, my lord. They have said only this 15 kg closing balance 15 and 15. Whereas from June 1st June to till 27, that midday meal served by the to the students, it is not discussed in the report, my lord. Only, my lord, they have said that there is earlier 2 quintal 11, and suddenly they have said that no midday meal served to the students on only 15 kg. This right, that means misappropriated by the headmaster. This is allegation. Instead of midday meal registered, they have not considered in the inquiry.
What is this loan?
My lord.
What is this
This
meaning
is
of
the
loan?
midday meal registered, my lord.
No. What is the meaning of loan? On the second column on the left hand side. Loan.
Loan. 1 quintal, 1.2 quintal. Mr.
2.60
Yes,
quintal.
this rice, I requested to follow, for 2 quintal and 1 quintal, this to rice, I requested to get the, to serve this midday meal to the students, my lord. I took loan this amount.
No, no, why loan? You have asked for loan or what? Loan, you got it on loan or what?
Yes, I got it in my second line. Serial number 10 and 21.
So therefore, we need to have their instructions as to how they have, what is there in the report by which they think that there have been misappropriation.
Yes, my lord.
So let us have that
Yes,
information.
yes, my lord.
Third, Current Council for the parties issue notice, returnable 2 weeks. The respondents are represented by MH Terang P, appearing for respondent 1, 2, 3, 4.
5.
Sorry, 5. And Mr. Soikia appears for respondent number 6. Then who's for mission director? Samakra Siksha. Mr. B. Chaudhary.
Sorry.
For mission director.
Oh.
Left. Since the learned standing councils appear for respondents 1 to 6, notices are waived, however, extra copies be furnished within a period of 1 week. 1 week?
My lord.
When can you serve copies?
Yes, yes, but even 2 days, my lord, we will serve.
Okay, within the course of this week?
Yes, my lord.
Within the course of this week. Stop steps on respondent 7 by registered post 80, as well as by usual course. Dusty is also permitted. Notice on the interim prayer, returnable on the same date. Let the matter be listed again on 13th March.
Yes.
13 March.
13, my lord.
1-3.
Yes, my lord. 8 no.
Yes.
Made, your lord. If, the petitioner is lordship pursuing his B.Ed training course on deputation basis lordship. And my lord, while he was
Now you are suspended.
lordship, I was suspended lordship only for that reason lordship. I was not allowed to lordship attend my regular courses in B.Ed training lordship.
Where is the order deputing you to attend?
Annexer 1 lordship. Page 12. My number is at page serial number 24 lordship, page 12. 24 lordship. Suspension order is at page 15, annexer 3 lordship.
Well, let us get the instructions, Harsh, Learned Council. For the
Lordship, only thing is that lordship on 1st of March lordship, the community survey program is going to be held lordship. This is a practical program lordship. Who attended program.
You are suspended.
Lordship.
Community program from
For a B.Ed course lordship.
for the B.Ed course.
B.Ed course is a practical program lordship, and I may.
It is to be held on when?
1st of March lordship.
1st of March.
Lordship, that is notification is page 18 annexer 6 lordship from the college.
When were you suspended?
I was suspended on 13/10 lordship.
Then what were you doing for all these days?
I was in the custody lordship.
When were you released?
I was released on lordship 11/12 lordship. I have made a representation annexer.
Even then, 11, 12 also, you now want to permit to participate in on first. First is just round the corner.
This is notification is on 23rd lordship. 3rd February.
Which notification?
This is annexer 6 page 18 lordship.
Yes, madam, get your instructions, see if he can be allowed to participate in that.
Yes, your lord.
This annexure 6. You have a copy?
No,
No.
your lordship.
Copy not served.
Was served, Lordship.
To whom?
The first time, Lordship, when before filing, we have the copy to the court.
You see if you can get some instructions whether he can be permitted.
Yes,
Today
your
is
lordship.
28th. 28th.
Yes, your lordship.
You see by 2 o'clock can you get the instructions?
Okay, your lordship.
Get it. At 2.
Obliged. Yes, right.
Most right.
May I please, your lordship. Here, lordship, it's for implement our party. State government of Assam, represented by its Secretary, Industrial Commerce and Public Enterprise. Through its instrumentally, namely AIDC, your lordship, it was taken over. for the
Any
Hindustan Bank.
objections? Implement of industries?
No.
We have not received a copy of the main petition.
You are appearing for
No, AID.
AIDC. And who is to be implemented? Industry
Now,
department.
In this petition. Industrially. 8 and 7, your lordship. 7 is state government of state of Assam.
Heard learned council for parties. This IA has been filed for implement of the industries department, government of Assam, as well as the state of Assam is represented by the industries.
Yes, your lordship.
And which other party you want?
Another one
AIDC is already
AI
there.
AIDC. No, your lordship. From this IA, AIDC will be party.
Taking implement of state of Assam, represented by the Department of Industries, Commerce and Public Enterprise, Dispur, as well as AIDC, as respondents 7 and 8 in the accompanying writ petition being WADC number 7332 of 2015. The respondents are represented by Mr. P. Chaudhary, representing the liquidator, respondent number 5.
In
And
some petition is respondent number 6, in some.
in the IA,
Right, 6.
He is there as 6. Respondent number 6 in the IA. No, respondent 5.
5 mile.
Respondent 5 in the IA.
And in the earlier order, my lord, state of Assam was already implemented.
I don't know they want it. State of Assam is already there
My lord, in the earlier petition, 2011,
in the writ petition.
yes, my lord.
By which order?
It was in earlier IA, my lord.
No, but was an order
Respondent number
passed?
5.
Was an order passed?
IA number, my lord, 3584. Okay, it was industries department. Respondent 5. In 3584, industries department is respondent 5. It is in
Seeking implement of so and so as party respondents in WPC number so and so. In view, no objections have been raised by the respondents. In that view of the matter, stands allowed. The state of Assam, represented by Department of Industries, Commerce and Public Enterprise, and the Assam Industrial Development Corporation, represented by Chairman cum Managing Director, are implemented as party respondents 7 and 8 in WPC number so and so. IA accordingly stands allowed and disposed of. The writ petitioner shall file amended post title before the registry within 1 week from today.
Again, my lord, the petitioner may be directed to furnish copies.
We will. Is this pending? IA 3584?
No.
No.
No. That is disposed.
In the writ petition, you write in view of the order passed on IA so and so. So and so are arrayed as party respondents. Petitioner is directed to file amended post title in the
Lordship,
before the
post title
registry.
is already shown in the IAM.
Sorry,
Post title, it's already in IAM. No,
you file it before registry so far as the writ petition is concerned. Amended post title. Since Mr. Kolita appears for Industries Department and Mr. S. Das for AIDC, notices are waived in respect of the newly impleted respondents. However, extra copies be furnished to all standing councils within a period of 1 week from today. The respondents are at liberty to file their counter affidavit if so advised, if not already filed. Matter be listed after 3 weeks.
Obliged. Obliged.
They,
Have you filed?
Lordship, here, Lordship directed us to file affidavit. Lordship, I received it lately yesterday, but after going through it, Lordship, some recasting has to be done. Mistakes were there. Lordship, short another some time, Lordship.
May it please the Lordship. Lordship, my senior is arguing a matter. My lord, I have instructions to pray for the matter to be fixed at 2, my lord.
At 2. Okay, come at 2 o'clock.
Lordship, I had informed them yesterday.
Come at 2 o'clock.
Yes, Lord.
Obliged, my lord.
May it please your lordship. Lordship, this matter may be taken up after some time, my lord. My senior is on legs before a coordinate bench. My lord. After some
But
time.
at 2 p.m. then your lordship.
I don't know.
After some
Everything
time,
can be at 2 p.m. Okay, let us see.
After some time, my
Yes, we'll see.
Well, Lord, the petitioner was they obtained instruction on whether the Supreme Court decision covered this, because this matter was pending before the Supreme Court. The Supreme Court has decided, but not finally, and now perhaps the petitioner have no case, my lord, after this. So let him come, my lord, and some other day, my lord, let him examine, because Lordship on the last occasion directed him to look into the judgment, my lord.
He's not here. What can be done? He's not here.
I have given
You hand over a copy if you have. Do you have a copy of that order?
Yes, I can.
You can hand it over. We'll
Yes.
pass the matter over for the day.
Lordship, Lord, that's better one.
None appears for the writ petitioner, Mr. Roy, Speaker Roy, Learned Senior Counsel, appearing for the respondents.
Yes, Lord.
Submits that the writ petition has become infructuous in view of the judgment and order dated so and so, passed in SLP number so and so by the appellate court. Judgment to Thailubo, huh? Period as it may, since the petitioner does not appear, matter be listed next week.
Lord.
Some order is passed by the full bench.
Yes, my lord. In fact, full bench matter is listed tomorrow, my lord.
Oh.
We have filed a review, my lord, and review is listed after a long time. Tomorrow it is listed, my lord.
None appears for the writ petitioner. It is submitted by Mr. N.J. Katonier that the
22
issues covered in the writ petition are presently pending before a full bench
Yes, madam.
of this court.
In review petition 149/2019.
A review petition 149 of
2019.
2019. Stop. The learned counsel submits that the review petition is listed tomorrow, i.e. date to be removed. Accordingly, matter be listed again after 2 weeks, enabling the learned counsels for both parties to apprise the court about the outcome of the decision of the full bench.
Here, I have obtained instruction as per the last order.
What is
the salary of the petitioner could not be paid because there was no retention. That is why.
My lord, my case is where, my lord, initially, my lord, the petitioner was appointed a stipend teacher, my lord, with condition that, my lord, he, my lord, obtained this, my lord, a diploma, my lord, a basic training. Thereafter, my lord, past basic training, my lord, then, my lord, regular appointment was made, my lord, regular salary paid, my lord. Thereafter, my service was also confirmed, my lord. After regulation, my lord, after confirmation, my lord, where is the question of retention, my lord? Kindly see, my lord, this
What is the instructions you have received?
After 2014, the post held by the petitioner, retention was not there, my lord.
But how will the petitioner know about that?
Yes, that I understand, but that whether he is entitled for salary or not, that is not.
So you go for post facto retention of the post.
In that case, obviously, my lord, we have to go for ex post facto
Do
retention. my
it
lord.
and release the salary.
But
Otherwise, there is no dispute that he is worked.
There is no dispute in the present instruction. There is no dispute regarding whether he is working or not, my lord. They have just said, my lord, that retention is not there, my lord. So my lord may fix it on next week, my lord, so that I can whether he is working or not, and secondly, my lord, whether he is
The whole problem lies in why the retention was not
exactly, my
applied
lord.
for or renewed.
Only reason they have cited that while the list was prepared, my lord, his name was left out, my lord.
So
that is the only reason what I can gather from the instruction, my lord.
Then
Or
you
else,
rectify, we close it, you rectify within a time-bound period. If that is the ground, if his
in that case, my lord, it is better to bring it on record by way of affidavit.
Your affidavit will take 6 months to come.
No, my lord. Since I have the instruction, I can file it, my lord, within a week, my lord.
My lord, by order dated 5/4/23, my lord, they already lost the chance of file because, my lord, several occasions, my lord, they obtained time, my lord, to file, but could not
No,
file.
if they filed their affidavit, your ultimate claim is what? Payment of
Payment of salary, my lord.
salary.
From 2014.
June 2000, June.
So this direction, if they file an affidavit stating that your name was left out, it will be easy for the court to pass an order.
Exactly, my lord.
What do you say?
My lord, if my lord, there, my lord, sure, because my lord, earlier occasions, so many opportunity given, my lord. If my lord, sure, my lord, then my lord, certainly it may give in. I have no objection to that.
When
But
can
my
you
lord,
file it? When can you file it?
Within a week, my lord.
Give us a date.
Yes, my lord.
Third learned counsel for the petitioner and Mr. N.J. Khatunian for the respondent. Secondary education.
Here, my lord, elementary education.
Elementary education. Then it is submitted that the instructions have been received and you'd like to bring it on record by way of an affidavit. Considering that several occasions have been granted to the respondents to file their affidavit and no affidavit was forthcoming. As the court is of the view that it will further the cause of justice, an opportunity is granted to the respondents to file their affidavit positively.
I'll file it by my lord 7th. Matter will be listed on 11th, my lord.
Be filed by 7th of March. Matter be listed on 13th March.
But
list accordingly. Yes.
Lordship, first of all, we have already returned a brief
long ago, and secondly, as per our information, matter is infractors, my lord.
Yes.
Otherwise, file affidavit at affidavit on page
You
11.
want to
Lordship.
file an affidavit in an infractious matter.
No. Lordship, one thing, the issue is already decided in another case, Lordship.
Then?
Thereafter, he filed this case, Lordship.
Then it is already.
No, it's-
What is that issue? Where is that order?
Lordship.
Where is that order? You said it is decided in another case.
Lordship.
Which case?
Lordship,
Lordship, there is a order.
You have returned the brief.
Already returned.
Then
Yes. Oh, mhm.
it is submitted by Mr. Your name, please.
H.J. Tamuli, I am appearing on behalf of Mr. A.K. Sharma.
A.J. Tamuli appearing on behalf of Mr. A.K. Sharma. It is submitted that the present councils have already returned the brief and they are no longer representing the present petition. Have you filed before the registry? An application, you file it before the registry. You file an application withdrawing from this withdrawing your wakalat before the registry.
No, my lord.
You file it.
Lord.
The council shall file an application before the registry for withdrawal of the wakalat. Mr. S. Mia appears for the Higher Education Department. Stop. In view of the submissions made by the Learned Council, matter be listed after 4 weeks, enabling the petitioner to make alternative arrangements. List accordingly.
Obliged, my
Yes.
My lord, in this case, my lord, we have received our, my lord, salary.
You have received?
Yeah.
Okay. Heard Learned Council to the parties. The petitioners' grievances have been redressed. It is submitted that they have received their salary.
Area salary. my lord.
Area salary.
Yeah.
For the period. Which period?
My lord,
For the period in question.
I have.
Accordingly, the writ petition stands dismissed as not pressed. Interim order, if any, stands vacated. Respondents who's appearing?
1 and 2, Dr.
Mr. C.K.S. Borua for respondents 1 and 2. Then Mr. Borpuzari for 3 and 4. 4 and 5.
Only 4, my lord.
Not for 5. Secretary Finance?
Yes, my lord.
4 and 5. And who's for project officer?
So I may take one.
Mr. C.K.S. Borua for 1, 2, 3. Mr. Borpuzari for 4 and 5. Writ petition stands dismissed as not pressed. Interim order, if any, stands vacated. Pending ayes are also dismissed. Pending ayes, if any, are also dismissed. Yes.
Obliged.
May I pray, madam? On the last occasion, the respondents sought for time to file affidavit, but no affidavit has been filed as yet.
Yes, Accountant General.
No,
May
the
I please your
education
lordship?
department is to file affidavit. Education department, higher education department is to file affidavit.
It is the Accountant General who has granted time. Yes.
May I please your lordship? My senior is on bereavement, so
Who is your senior?
Ardhar.
Anything to be filed by the Education Department?
Lordship, I need some time, Lordship, to file my affidavit, Lordship. Not received any instruction, Lordship.
Your pension has not been released.
My gratuity has not been
Gratuity.
gratuity.
But Rule 22 doesn't talk about gratuity.
No, DCRT.
Ah.
Come retirement gratuity. DCRT.
The CRT.
But there is no criminal case pending against me or the departmental proceeding has been initiated.
So you let them look into the grievances. We remand the matter to the authorities. Have they passed any order?
No. Earlier they have passed in 2018.
Where
That
is
is
that
in
order?
page 11, page 66. Page 66, madam.
66.
But that was in 2018. And 4 years as stipulated in under the rules have not elapsed till then. But in 2022, 2020, my lord, 4 years has elapsed. So thereafter they have to take a fresh decision, man. In terms of Rule 21, man.
You find out at 2 p.m. whether any decision has been taken.
Sir, can it be taken tomorrow, Lordship?
Tomorrow, okay. Tomorrow. You find out.
Yes, sir.
Tomorrow. We'll have it tomorrow, list tomorrow.
My lord, in this case, I am referring on behalf of Respondent number 3 and 4, my lord.
We're taking up tomorrow.
Yes. Criminal case is pending.
Very well. We'll find out. Let them find out what is there tomorrow. Tomorrow, huh? Yes, sir. Huh?
May I please, Your Lordship?
Being to me. एक बोल लो, अभी तो you inform them that we'll follow up at 2. Yes.
May I please, Your Lordship? Lordship, this stipulation is for non-payment of area salaries and for compassionate family pension, Lordship. Lordship, my case is that, Lordship. So far, the affidavit of council is concerned, Lordship. The finance department has omitted to accord ex post factum approval, Lordship, in respect of the service of my husband, Lordship, along with other 9. They have not paid the areas as well as compassionate family pension, Lordship. Lordship, the fact is that in the year 2007, Lordship, Council, following due process of law, Council appointed 10 numbers of persons, Lordship. But, Lordship, they could not pay the salaries, Lordship, due to some technical errors, for which the petitioners, all the petitioners approached this honorable court by filing 4 different writ petitions, Lordship. Court monitored that matter, Lordship, and subsequently followed by an instruction of the Council, Lordship, case was disposed of. Accordingly, proposal was submitted before the Finance Department. Finance Department accorded ex post factum approval of 9 petitioners, Lordship, and Lordship, they omitted to accord the name of my husband, Lordship, in that approval, Lordship. Lordship, may kindly come to the page number 39, Lordship. Page number 39. Proposal for 10 numbers of appointee, Lordship. 39. Again, Lordship, page number 41, Lordship. Here, my Lord, serial number 5, my name of my husband, Lordship. Again, Lordship, 42. Here also, Lordship, name of my husband was shown at serial number 5. And then, Lordship, the Finance Department concurrence is at page, Lordship, 43. Annexa Q. Finance Department accorded the approval, Lordship, of 9 petitioners, Lordship. And they omitted the name of my husband, Lordship.
Yes.
Lordship, I am appearing on behalf of Dima, Lordship. Lordship, I have filed our affidavit, Lordship. In that, we have stated that the
name of the deceased husband of the petitioner was not accorded by Finance SIU department. So
But
we are not able to.
Was it sent?
Yes, Lordship.
Where have you enclosed?
We have
Was
not
it sent before the authorities?
Yes, we have stated in the affidavit.
Stating will not do. You have to show us how you have sent it. Why have you not enclosed a document that it was sent but rejected by the finance department?
That document we have not, we didn't receive. So,
Where have you stated?
Lordship, in paragraph number 9.
Paragraph 9.
May I read, Lordship? That with regard to statement made in paragraph 9 of the read petition, the answering department begs to state that the area salary proposal of the deceased husband of the read petitioner was returned with observation, and the deponent, after mitigating all the observations, resubmitted the same, and finally the Finance SIU department by letter dated so and so accorded the approval of 9 new appointees. In the said approval, the name of the petitioner's husband was not indicated, though in the proposal his name was sent to the Finance SIU department for approval.
Number 3 important. Page number 8 also important.
But this kind of was not indicated, but so who's for the finance? Why have you rejected it?
It appears, my lord, that it is not a case of rejection per se. His, her husband names does not figure, my lord, in the list of, my lord, approved appointees, my lord.
Correct, but why was it not approved?
My lord, that I will have to seek the instructions, my lord. So will kindly accommodate me, my lord.
Get your instruction. Third, Learned Counsel for Parties. Mr. Sharma, Learned Standing Counsel, NCLs. Submits that an affidavit has been filed on behalf of respondent by. In the said affidavit, there is an averment that the proposal for sanction of payment of area salary of the deceased husband of the petitioner was forwarded, but the same was not approved by the finance department. Stop. Para Mr. R. Borpuzari, Learned Standing Counsel Finance, submits that he does not have any instructions today. He prays for an accommodation for 2 weeks to complete his instructions. Mr. Talukdar, Learned Counsel for the petitioner, submits that this being a question of release of family pension,
Area salaries as well as the compassionate family pension.
area salary as well as family compassionate family pension, matter be listed on a fixed date. Accordingly, matter be listed again on 13 March, 15 March.
15th of March, yes, my lord.
15 March.
Yes.
Obliged, Lord.
I'm so obliged.
Obliged. বুঝছে না? None appears. Yes, any instruction?
Lordship, we need some more time, Lordship. At least 4 weeks time, Lord.
Mr. Upadhyay, Learned Standing Counsel Irrigation, prays for further time. Since none represents the writ petitioner today, matter stands adjourned. Enabling for 4 weeks, enabling Mr. Upadhyay to obtain the instructions. You are for? Learned Counsel appeals for respondent number. This is for Karbi Anglong. 3N 6. And Mr. Borpuzari for finance.
My lord, for 7 and 8, my lord, newly
7 and
created, my
8.
lord.
7 and 8.
My lord.
List after 4 weeks.
Obliged, Lord.
May it please your lordship. Lordship, here in this matter, MS S. Sharma appears, lordship. He is handling the brief, lordship. Due to some personal inconvenience, he is not here in court, lordship. Can this matter be taken up after a week, lordship? Any date, lordship? after a
Next week. Next week. It is submitted by Mr. D. Upamanyu that counsel representing the respondents is not available. Therefore, seeks accommodation. Mr. Bora, counsel, submits the matter be listed next week. Accordingly, matter be listed next week.
Highly obliged.
My pleasure, Lord. So this application is for implementing the treasury officer as well as the bank authority. Not in the read petition, and this application has been preferred pursuant to the court's order, Lordship. Lordship, the case is that during the pendency of this case, Lordship, Director of Pension has, Lordship, finalized the pension of the petitioner, Lordship, but same has not been released either by the fault of the treasury officer or the bank, Lordship. I have submitted all the requisite documents, Lordship, including the bank
In the
statement.
IA, you write hard learned counsel. This IA has been filed for implementation of
Implement or exponent number, Lordship. Treasury officer, exponent number 7.
Treasury officer and the SBI.
Lordship, the Assistant General Manager, State Bank of India, Lordship, exponent number 8. And branch manager, State Bank of India, Patsala branch, Lordship. Exponent number 9.
Respondent 789.
7.
Accompanying the petition, the WPC 348 of 2022. Mr. R. Borpuzari appearing in final.
I am first.
So here appearing for the Director of Pension, appears for Director of Pension. Then Education Elementary. Who's for elementary? Mr. Pegu appears for elementary education. The respondent councils representing respective respondents. According to the I stands allowed. The Treasury Officer, Patsala Treasury, Kumar, Assistant General Manager SBI, Centralized Pension Processing Center, Lokara Sariali Kumar, and Branch Manager SBI, Patsala Branch Patsala are carried as respondents 7, 8, and 9 in WPC 2348 of 2022. The report is the line of it. Orders relief of 4 in the accordingly, the I stands allowed at this program. The applicant will file amended post title before the registry within 1 week from today. In the writ petition, you write in view of the order passed in IA number carried as respondent 789. Petition to file amended post title within 1 week from today. Meanwhile, the notice be issued to the newly implemented respondents. Mr. R. Borpuzari, Studying Council, Finance, appears on behalf of the Treasury Officer and accepts notice that notices are waived. However, extra copies will be furnished within 1 week from today. Insofar as respondents 8 and 9 are concerned, steps be taken by usual course and by registered post AD within 1 week from today. List after 3 weeks.
Lordship, we were to file reply to the affidavit filed by the respondents, Your Lordship. But I have not been able to make contact with the petitioner, Your Lordship. For 2 weeks time.
The only thing, Your Lordship,
For
can
last time,
see,
yeah.
they have taken an interim order in the year 2021 and they are enjoying the fruits.
and more than 2 years has gone by in the meantime. And what they have challenged, my lord, transfer to one place to another. My lord, what is the violation, my lord, your lordship, can we see that? I'll take your lordship to the transfer order, which is that page.
So we are not disposing it of today. So we'll fix another date, let them file their reply in the
My
meantime.
lord, recently, my lord,
Your lordship.
my learned friend paid in another court, your lordship, kindly see. They have said that more than 2 years has gone by, so the matter can be disposed of, and according to their prayer, my lord, the same council they paid. Now,
It's a
this
different case, your lordship.
same case transfer order, why you are saying all this?
This is about 2 years only. That was
Don't
about 3 years.
mislead at
That
least.
is why I pleaded like that, your lordship.
The
Only
same
two-
fact here, the same bank,
It can wait for 2 weeks, your lordship. On the next.
well,
day,
what
lordship
reply
may
they will
dispose
get?
it of.
Well, they are challenging the guidelines. It has got no enforceable right at all,
There is an interim order,
my lord.
but that was passed inter-party. Interim order was passed inter-party.
Without hearing us, it was
We
given.
don't know your name is recorded.
No, it, in the next, my lord, it was passed. Initially, my lord, without hearing us, the order was passed.
9/5/2022. Interim
My lord,
order was passed.
my lord, one thing your lordship kindly see, they are saying, under the executive instructions, they can serve in a place 3 years. Now, that is an executive instruction and it's a routine transfer. 268 bank employees have been
No,
transferred.
what we want to know is, we'll see, this is an order passed inter-party after hearing the council in 2022. So therefore, um, uh, hmm,
Now, only thing, can I say one thing, my lord? at this
we'll give them a period of 2 weeks. If they don't, then we dispose of the matter.
That's it, your lordship. That is what
Even if
I
they don't file.
Well, instead of 2 weeks, your lordship kindly give 1 week time. Because I know that nothing to be replied here. But since they want to buy time, your lordship give them 1 week time.
There is no question of buying time, your lordship, because I have not been able to.
We'll fix it on 14th.
14th of March.
14th of March,
Oh,
by which time let them file any reply or
Yes,
whatever
yes.
they want to file.
Yeah, that's it.
And my lord, your lordship, the endeavor may be taken to
Yes, yes,
dispose.
we'll mention that. Third,
On that, it will dispose of your lordship.
Yes,
I don't.
learned counsel for the petitioner, Dr. Raj Sharma, submits that further 2 weeks time be granted. I reply on behalf of the petitioners in response to the affidavit filed by the respondents. So, Mr. S. Doctor and City Council, assisted by M.S. R. Tahari, submits that sufficient opportunities were granted. However, no reply affidavit has been filed. They are enjoying a stay order with effect from 15/9/2022, 9/5/2022, and therefore further enlargement of time for filing their affidavits is not required, and the matter can be disposed of. Matter needs to be disposed of. In support of his contention, he is placed before the court the order dated 7/2/2024 passed in WPC so and so, upon which Mr. Dotto relies upon and submits that in a similar matter, the counsel representing the petitioner had submitted that since um, 3 years have been completed, there is no need for keeping the writ petition pending, and the writ petition was closed and the interim order vacated. Don't say counsel for petitioner, it says the coordinate bench has held that in view of the period of 3 years which had undergone pursuant to the transfer, writ petition was closed, the interim order was vacated. Mr. Dotto submits that similar order is called for this writ petition of Para. Having heard learned counsel for the parties, considering the prayer made by the petitioner, to file a reply. And also taking into consideration the submissions of the respondent counsel who has seriously objected to the prayer made. Let the matter be fixed on 14th March, by which date the petitioner may file the response, may file the additional affidavit in reply if so advised. And on that date, on the next date fixed, an attempt will be made to dispose of the rejection.
Yes, sir.
Respectively on 14th March.
14th.
Yes, Mr. Bhaiya.
My lord, matter relates to my lord pension. My lord, final pension has not yet been released, my lord. There are some instruction is required from the accountant general, my lord.
My lord, my senior is on bereavement, so can the matter be fixed after 2 weeks?
My lord, may kindly, I would not have object, my lord, but my lord, may kindly peruse the last two orders, my lord. The same issues, the senior was also absent on the last occasion. That the, my lord, a small instruction is required, my lord, that they have raised an objection by the department that I do not put the nominee column and was blank. And that's why, my lord, my family pension cannot be, my lord, released. My pension.
So when is he likely to be back?
After 3 days.
Huh?
After 3 days.
After
After
3
3
days. So we'll keep it after 1 week, Mr. Bhuiyan.
My lord, my last situation, my lord, we can.
It is submitted on behalf of Mr. R. Dhor. The learned counsel is in bereavement and therefore accommodation is sought for. Mr. R. A.R. Bhuiyan, learned counsel for the petitioner, although does not object to the prayer made, however submits that matter be listed on an early date. Mr. Rai Bodhakur appears for PH. Let the matter be listed again on 13th
March.
13 March.
Oblige, my lord.
Several occasion, my lord, respondents take time for file affidavit, my lord.
Only one occasion, my lord.
How many more do you want?
My lord, regarding this matter of illegal appointment, petitioner was accommodated as tutor, my lord.
What is
So,
the prayer? What is the
Prayer, my lord, I challenged the perception condition, my lord, page 76, my lord. The condition the accommodated tutor will get prospective effect from 1/11/2020 only, and she cannot claim any benefit whatsoever in respect of past service rendered by. The death condition, my lord, petitioner have no bargaining power, my lord. There's the apex court judgment, my lord. If any time we can challenge it, my lord. So I challenge that, my lord, perception, my lord. Already, my lord, area.
You are claiming area salary.
Yes, past service, no, not only area, past service along with, my lord, old pensions.
And why was it denied?
Denied because of that we are in on there is another case is pending also.
No.
And
While claiming your past services,
my lord,
from which period you are claiming your salary?
the salary from, my lord,
2020, my lord.
2000, no, my lord, in the
2000. Prior to 2020.
2003, my lord.
2003.
My lord. There is another case is pending also, my lord.
No, another case
within
is
that,
different.
my lord, they issued, my lord.
No, we are asking you that you are claiming your past salary.
Past service, my lord.
Past service. Not salary.
Including that, my lord. Because of that,
What
my
is the
lord.
meaning of past service?
Past service.
You have retired or you are not retired?
Not retired, my lord, they given the
You want-
condition, putting
you
the
want-
condition only the pilot
You want your earlier salary,
salary, my lord.
you want the period of services you have rendered to be
Right.
taken into account for the purposes of seniority.
Seniority.
Now, from which period you want your service? You're claiming your salary, area salary.
My lord, October 2003, my lord, that case is still pending before this honorable court. Paragraph 16, my lord. Paragraph 30, page 13.
This is the case where you are one of the petitioners.
Yes, ma'am.
You are claiming the salary.
Salary, my lord, from 2000, October 2003, ma'am.
To which period?
The period, my lord, October 2003, from the October month of October to paragraph 16, my lord. That having no other alternate, the petitioner along with 8 others opposed before this honorable court by filing writ petition so and so, praying for release of their salaries from the month of October 2003, and honorable court by it order dated so and so issued notice of motion. This said case still pending before this honorable court. And in the meantime, my lord, they.
What we are asking you,
my lord,
either you pursue the earlier writ petition of making your claim
my lord.
for the salary as well as the
My lord,
the service.
that writ petition, they objected that already, my lord, this appointment was, there is a condition. You cannot claim in past service.
correct.
Without challenging that, it cannot, my lord.
No, you are not getting, you are claiming two benefits.
My lord.
One benefit, you are already claiming your earlier benefits in
My
a
lord.
different writ petition.
My lord.
Now you are again reiterating those benefits by challenging the subsequent order.
Condition, my lord.
Now the question is, these options are available to you. If you are aggrieved by this order, don't accept it. Why are you accepting this condition and be appointed as a tutor? Don't
My lord.
accept. You continue with your services and pursue your claim for earlier salary, area salary.
My lord, if that persistent is there, condition is there.
What
my lord.
condition?
The in appointment letter.
This
my lord.
for appointment of a tutor. You are
Tutor,
not
but-
appoint-
but
what were you appointed as?
I'm an assistant teacher of LP.
That's
school.
right. So you claim your benefits as an assistant teacher. Why are you accepting the appointment as tutor?
My lord, but there is some compelling circumstances because of they did not, because of the salary. Without salary, it cannot run, my
That's
lord.
right. We are asking you. So without salary,
My lord.
you have not been receiving your salary.
Not salary. Now they
Then why have you not received those salary for the services you have rendered? From 2015, there's a writ petition pending.
My lord. My lord, matter will allow with it, my lord.
No, along with we'll hear, but we want to know. See, you have been given two options.
My lord.
You have the option of continuing as an assistant teacher.
My lord.
Claim your salary.
My lord.
Fight it out. Or you abandon everything and you accept a tutor. This you are saying that is not permissible.
My lord, that's why, my lord, that there is a judgment, my lord.
No,
in front of the
judgment
court.
is
Yes, my
judgment
lord.
is correct.
Same issues, my lord.
No,
The
judgment
honorable
is
court
correct,
says
but
that.
that judgment is on the basis of a or was offered as to people who were not initially appointed. Here is a case where you are working. This is your claim.
Yes, ma'am.
So when somebody offers you a post as a tutor, why have you accepted?
My lord, that case that they say that without challenging that condition, that my lord,
How can that be?
maybe because of that already this condition is there, my lord.
No. It is your submission that this WPC 3195
My lord.
is for releasing of salary.
Releasing of salaries.
Releasing of
So
salary.
within the pending of this case, my lord, they issue
It
the
is not a-
appointment letter, my lord.
It is not a case that you are retired from service.
My lord.
So releasing of salaries means releasing of area salary, then including current salary for the post in which you are supposed to be working.
My lord.
So why have you abandoned that claim?
But
And accepted this
but
appointment?
duty did that condition, my lord.
What condition?
That I am the receiving, I am taking this appointment letter and joining that. My lord, that you have not claimed the says that you are there
That is because you are joining as a tutor.
tutor.
Who asked you to join as a tutor? You work as an assistant teacher. You are appointed.
My
That is your claim. That
Right.
this is on the basis you are claiming your area salary.
Right.
So when you are working, it is
Right.
your claim that you are working and claiming your area salary as an assistant teacher.
My lord.
What compelled you to accept the services as a tutor?
But the compelling circumstances.
What is
my
that
lord,
compelling
Because of that, the salary was not received, my lord. So I have to, my lord.
So
Living my-
essentially, you have abandoned 2015 writ petition.
my lord. So thereby now I'm going to challenge it.
You are challenging it. So
My lord,
there is no such thing that the condition cannot be applied. But here is a case, the judgment you are relying on
my
are
lord.
in respect of people who did not have regular source of appointment. Here is a case, according to you, you have made a statement,
My lord.
perhaps sworn by an affidavit,
My
that
lord.
you are working,
I'm okay.
therefore you are claiming your area salary.
My lord.
Then why did you abandon that and go and accept the,
My lord, without a statement, my lord, they give the appointment letter in.
who asked you to accept the appointment letter as a tutor when it is your claim that you're working as a assistant teacher?
My lord.
Why? To accepting the appointment letter as a tutor
My lord.
gives you a new lease of appointment. The earlier one is gone. Why have you abandoned that?
Because of that.
Unless there is a cloud on your original service, which you know.
But if there is a putting in condition, but with a because of that, employee have the power, but we have no any bargaining power.
No.
So there, Honorable Supreme Court says that you at any moment you can challenge it, man.
You can certainly challenge it.
Yes, ma'am.
But the question, first you have to answer this question,
Ma'am.
that why have you abandoned your earlier claim as a teacher, as an assistant teacher claiming the arrear salary?
Yes, ma'am.
Your claim is not as a tutor. Your claim is as an assistant teacher.
Assistant teacher.
While that matter was pending, they have offered you as forget everything. Now you accept tutor and abandon all your claims. You have accepted it. Why?
That's why I'm written mal as to why mal. For the compelling circumstances, because of that, without salary cannot run.
No, but then you'll have to make a categorical statement that your arrear salary aside, you are working and your current salary has been released. You are allotted work. So perhaps there is a cloud on your earlier appointment.
That can be
That will have to be found out.
My
Third Learned Counsel for the party. Notice issued here. Yes. The file affidavits. Respondents, Mr. Pegu and Mr. Korpujari, based for the respondent. File your affidavit.
Yes.
List after 3 weeks.
Yes.
Do you want this matter to be listed with the earlier writ petition?
Let them file affidavit there.
Very.
Mark.
Okay.
May I please honor? Honor, actually, my senior is not well today. Kindly extend this matter.
After 1 week. List after 1 week. Mr. Kupan appears for university. Anyone else? Mr. T. Upamanu for higher education. Who is your senior?
SM Nath.
Matter be listed next week.
Next week. Oblige.
My lord, in this case, I'll pay affidavit, my lord.
Sir, I have received instruction. Dada.
What
The
instruction?
instruction-
Tell us what instruction?
Sir, the petitioner has been giving the minimum of the pay scale and the arrear amount already has been received by the petitioner. I have instruction.
In this matter, my learned friend was filed to affidavit, my lord.
Instruction.
Direction is there, my lord.
I will file affidavit. I have
They
received
have
instructions.
furnished the instructions. You agree, we'll close the matter. Your client has not spoken to you after he got the salary.
Not aware, my lord.
Yes, sir.
He is aware, he has not made you aware.
Copy also.
Copy may be done.
Mr. Counsel, your client is aware. He is
The illiterate
made it a
lady-
point,
one
he's
illiterate
made it a
lady, my
point
lord.
not to make you aware. It is
One
submitted
copy
by.
may be directed.
I will give.
That copy we can't direct. That is between lawyer and client. If she wants to share, it is her call. Third Learned Counsel for the party, MS MD Bora, Learned Standing Counsel.
Open the file, sir.
Standing Counsel, which department?
Transport, my lord.
Transport. Submits that the claims of the petitioners have been pressed and the minimum of pay scale
Lordship,
along with dearness and medical allowances
my lord.
have been released to the petitioner. Stop. Learned counsel appearing for the petitioner, however, submits that he has not received his instructions. He has no information from the writ petition. Accordingly, prays for a week's time.
Yes, ma'am.
Matter will be listed after 1 week.
Deeply obliged. Lordship, may keep my instruction as a part of the record, my lord.
The instructions furnished by the counsel for the petition for the
Respondent,
respondent are kept as a part of the case report.
I am deeply obliged, my lord.
Yes.
So here we have received one correspondence from the Department of Social Justice and Empowerment, but Lordship, the main correspondence is actually from the principal of school for hearing impaired, Lordship. And what is, Lordship, that the petitioner Mamuli Kokoti was engaged as casual employee by then social Services for 3 months and subsequently extended until further.
Who is to furnish their information?
Basically, this social justice and empowerment, because she was been
Who represents social justice and empowerment?
today also it is RM Das.
The RM Das is there for social justice and empowerment.
So what instructions have you got?
In this case, social justice and empowerment is not a main party also.
Direct them. Earlier it was a part of social welfare only.
Yes.
Then bifurcated.
Yes.
What any instructions you
No,
have?
Lordship. We don't have, we didn't know also that the case has been listed.
49.
Third learned counsel for the parties, it is submitted by Mr. C.K.S. Borwa, learned counsel appearing for the social welfare department that the social welfare department has now been bifurcated into
Social justice, social empowerment and justice, social justice and empowerment division.
social justice and empowerment and women and child.
Yes, Lordship.
And Directorate of Women and Child. The present writ petition, the grievances of the present writ petitioner are directed against the Department of Social Welfare and, Social
Justice and Empowerment Department.
Social
along with
Justice and Empowerment
Department.
Department, which department, however, is not arrayed as a party. Para. Considering the submissions made, this court on the oral prayer of the learned counsel for the petitioner directs that Department of Social Welfare and Justice.
Social justice and empowerment.
Justice and Empowerment be arrayed as a party respondent. Sorry, give the name again, Social Justice
And empowerment department.
Social Justice and Empowerment Department, Government of Assam. Be arrayed as a party respondent number 6. The petitioner counsel will file amended course title to that effect and before the registry within 1 week from today. Para Mr. RM Das, learned counsel has appeared before the court.
No, Lordship, I am C. Sharma on behalf of Mr.
Mr. C. Sharma has appeared before the court on behalf of Mr. RM Das and submits that Mr. Das is the standing counsel of Department of Social Justice and Empowerment. Accordingly, let the matter be listed after 2 weeks. Meanwhile, the Department of Social Justice and Empowerment will furnish necessary instructions with regard to the claims of the writ petitioner made to its standing counsel. Both the writ petitions are the same.
Both the writ petitions same.
So in the second also you need social justice and empowerment.
Yeah.
So I think
Next order.
almost 6 in this case also.
Same order. Same order, you file amended post title before registry in 1 week. Published after 2 weeks. Mr. Counsel, extra copies of the writ petition be furnished to the learned standing council and names of all registry to reflect names of all standing councils in the course list.
Mother, yes, as part of the previous order, they asked me that they have sent some papers to the petitioner. Petition, nothing has been issued, that they have got no paper still today. No paper. They are telling lie. Already in my read petition, if you lordship may kindly go through, at page 57, 58, 59, the area proposal has already been given. 22, 21, and 22, 20, 20, and 22. 57, 58, 59.
By which communication you have sought for the documents? In the last order, we have recorded your submission that documents were sought for but not received from the petitioner. In view of the submissions today that no papers have been received, you show us by which document you have sent it and when? After some time, okay. Or we have it on Monday?
Monday.
Or after some time after 2 p.m.?
On 15, my lord, they shall have to give you proof, to which they have sent some.
All right, on 15th, 15 March.
15 March.
On 15 March, list on 15 March, on which date the learned Standing Council Elementary Education will furnish the necessary documents by which communication was stated to have been sent to the writ petitioner requesting for certain documents which are stated to have not been received from the writ petitioner. Stop. This direction is issued by the court in view of the submissions made by the learned counsel to the petitioner that no such document has been, no document or no communication has been received from the department by the petitioner requesting for furnishing of documents. Consequently, the petitioner is unaware as to what documents should be furnished and therefore the same could not be furnished. Let the matter be listed on 15th of March, or by which date the respondent department will furnish those communications stated to have been addressed to the writ petitioner without fail. List on 15th.
May please, your lordship. Lordship, in this case, lordship, we are praying for direction from the department, that is JNDA, lordship, for finalizing or approve the draft Guwahati Metropolitan Development Authority Employee Service Bylaws, lordship. The draft has been made in the way back in year 2020, lordship. And thereafter, lordship, everything kept on stagnant, your lordship.
Your lordship, regarding this matter, we have received the instructions, the affidavit has come, we are going to file it within the course of the day, your lordship.
If it is done within the course of this, very fine, lordship. Otherwise, lots of days they have taken, lordship.
We are recording your submission that you're filing it within the course of the day. Heard Learned Counsel for parties. Your name?
RM Barua, your lordship.
MSRM Borua, Learned Counsel.
I'm appearing for Mr. P. Naik, your lordship.
Appearing on behalf of Mr. P. Naik, Learned Standing Counsel, GMDA, submits that an affidavit has been received. The affidavit on behalf of the department is likely to will be filed during the course of the day. Stop. Taking into consideration the submissions made by the learned Standing Council. The matter stands adjourned for 2 weeks, enabling the respondents to file a reply affidavit if so advised, upon being served with a copy of the affidavit in opposition. Mr. Borpuzari appears for respondent number
Finance
2.
Department.
Respondent 2.
My lord. Lordship, may I pray for fixed rate only because it is a pension matter, Lordship. Fixed rate, Lordship.
Yes.
Maybe on 13th, your Lordship, or maybe 18th of March.
List on 18th.
What's up, Lordship?
Lordship, this petition is filed for the re-regulation of the service after 12 years of continuous service. In the Lordship, in the earlier occasion, Honorable Court directed to obtain instruction from the respondent authority.
Yes, any instructions? Who's for the respondents?
The instruction is still awaited, Lordship. Yes.
Further time is prayed for by the learned counsels for the respondent, as they have not received their required instructions in the matter. MS, your SD Saikia, learned counsel appears for the petitioner. Matter stands deferred by another 2 weeks, placed after 2 weeks. Give your names.
May I please your lordship, my lord, this matter has been wrongly listed, my lord. The matter was last listed on 21/2, where the honorable court was pleased to give 2 weeks time to the petitioner for filing affidavit, respondent, my lord, to file affidavit. 21/2, last listed on, 2 weeks time was granted to the petitioner.
Last order is 12/12/2022.
No, my lord.
This is the last order available here. WPC 7982.
Yes, my lord.
This is the last order.
No, my lord, matter was listed on, last listed on 21/2/2024.
Yes, how? The last order available here is of December 2022.
I have a copy of the order, my lord.
Bhulbhai.
Oh.
Illegal.
7892.
Oh, there is some mix-up.
Oh, acha.
This Kundu file ID 7982. Yes, 7982.
7892, my lord.
Huh?
Our it is 7892.
Okay. The 7982 is listed. So
our names are reflected in the call list.
Okay. They're wrongly listed. So we can't even
Yes,
pass an order because it's not here yet a matter wrongly listed in place of WPC 7892 of 2022. Accordingly, registry to verify and list the matter again and list the appropriate matters before the appropriate bench. Yes. Yes, State Bank affidavit is filed.
Yes, ma'am.
Have you received a copy?
Yes, your lordship.
So
you were supposed to file the reply to that affidavit, your lordship.
We are not objecting to anything, madam.
No, you are supposed to file or you want to file?
We want to file.
You want to file.
Yes, sir.
So how much time do you require?
1 week time maybe given.
1 week. Heard, at the request of Mr.
Are Mazumdar.
Mazumdar. Matter stands adjourned for 2 weeks, enabling him to file a reply affidavit to the affidavit in opposition filed by the respondent, State Bank of India. Mr. Sharma, U Sharma, appears for the State Bank of India. Mr. E. Soikia for Pension Department. Mr. M. H. Loshkor for
Number 9.
Respondent 9. And L- P. N. Sharma for 1, 3, and 4. J. Das for Accountant General and Finance also. Mr. Bor Pujari for Respondent number 8. List after 2 weeks.
They were also supposed to file an affidavit in reply against my affidavit in opposition. Last
He
time.
doesn't want to file. We can't compel him.
Yesterday I filed here.
You filed.
Yes,
It is also submitted that a reply affidavit has been filed in response to the affidavit in opposition filed on behalf of respondent.
9.
Registry to trace out the affidavit and connect with the case report. By the next date. This
Obliged.
after 2 weeks.
Any date?
You want a date? 18th. 18th of March.
Obliged. Maybe the lordship. Non-payment of our area salaries and other legitimate dues, lordship. And in this case, already several their respondent authorities taken some instruction, but till now they have not paid single of money. And you know, kindly see the last order 3/4 of 2023. In this order, the Honorable Justice D. Borwal given a direction, if not paid or delay, thereafter court may consider the imposing interest upon the respondent.
Thereafter, several orders have been passed.
Yes. Yes, sir.
Last order would be 12/12/2024.
2024.
Yes.
Lordship, may I please?
What is that?
Lordship, here, the period for which they are claiming the area salaries, he was working in ME school, your Lordship. So, the DEO, the District Elementary Education Officer, they have informed us that they have found no records with regard to the petitioner, your Lordship. So the petitioner has been communicated, your Lordship, several times, and the petitioner is not cooperating, your Lordship. Since no records has been found, your Lordship, it seems that she did not hand over the records, your Lordship.
What records?
Lord-
Her records.
Lordship.
How can she have access to the records? She was working as what? Headmaster, headmistress.
Yes, sir.
Lordship, because she retired as a,
She is retired on 31st of 12,
And-
19.
after her retirement.
What
she-
records are necessary? Service book.
Lordship, Lordship,
Service book is not available.
Lordship.
Must have been sent to the pension
pen-
department.
Lordship, no proposal has been sent to your Lordship.
Now what, you'll have to reconstruct the service book.
Lordship. So that is why the petitioner has been
So what are you expecting her to give you? Service book.
Lordship,
She's
the other
not-
informations also. Your
What
Lordship.
other information? You specify that these informations are necessary.
Yes, sir.
Lordship.
You're only saying that as per report of so-and-so, no record is available.
Lordship.
What records are necessary?
Lordship, because she was also the drawing and disbursing officer, your Lordship, because she was the headmistress.
No, for
Lordship.
clearing her pension proposal, what
Lordship.
documents you require, why can't you specify?
Lordship. Lordship,
If these
then-
are not available with the petitioner, you'll have to find out a way to get it.
Lordship. But the petitioner has also to respond, your Lordship. She is not responding to the
Like,
communications.
Each and every document already we are submitting before the concerned authority. And
Have you,
yes,
en-
because
have
they
you enclosed any such document in the writ petition?
Mm.
Where did you get a copy of this service book? Extract of the service book, page number 17, 18.
Yes, Lord.
From where have you got it?
Already we are mentioning page number 17 to 19, Lordship, the service book.
I know you have given an photocopies.
Yes, Lordship.
So where did you get these photocopies from? There must be an original. From where have you got it?
Thought they may be given next day, definitely I will produce it. Very definitely.
Oh,
That's
no.
something that video.
That's a separate program.
Have you been served with a copy of the petition? Do you have a copy of the petition?
Lordship.
Then this writ petition encloses a service book, part of the service book.
Yes.
That's the, it's by the
What is
petition.
that? Where is the detailed report by the DEO?
Lordship, DEO,
Where is the detailed report? Stating what?
Lordship, because
There is a report from DO Lordship
Stating what?
stating that with the area salary after transfer, the unassigned revenue transfer to inquire her claim of area salary and accordingly PO Pathakandi inquired the matter, submitted the report
copy and
where he stated that Basanti Sinha was transferred from Pratapgarh ME School from Patharkandi Girls ME School. After her transfer, she was released and joined the Pathargarh ME School. And later on, the said Pratapgarh ME School was amalgamated with the Pratapgarh High School under Secondary Education Department. The present headmaster of her previous assignment, that is Patharkandi Girls ME School, stated that no record relating to her area salary is found available in the school. SC, petitioner of the case, did not hand over any of the records of the school, and later the then headmaster opened the new record as reported by BEO Patharkandi. He has
She was
communicated
working. She was working as what?
She was lastly working as a headmistress, and being a headmistress, she herself was the DDO.
Yes, sir.
Drawal and disbursing officer, and the original records of service books are kept with the DDO, and she herself was the DDO. While getting transferred, she did not hand over any of the documents, record, to the new headmaster. And subsequently, number of correspondence has been sent to the petitioner, but as my learned friend has already apprised your lordship, that she is not cooperating, she is not giving any. Even in one instance, she refused to accept the letter from the school also. And a similar instruction also received.
Heard learned counsel for the parties, standing counsels for the education, elementary, secondary.
Both lordship here, because the school.
Initially, she was in ME.
She was in ME.
Appearing for the elementary and secondary education, jointly submit that as per instructions received, no records relating to the petitioner in respect of her claims for area salary are available. Stop. It is submitted that the petitioner was initially appointed in Patharkandi Girls ME School.
Lordship.
And subsequently,
she was transferred to Pratapgarh ME School.
She was transferred to the Pratapgarh
ME School.
ME School.
Lordship.
Which school subsequently was merged with Pratapgarh Public High School.
Lordship.
And finally, she superannuated from Pratapgarh Public High School as headmistress. She superannuated as headmistress. Yes. Stop. Learned counsel submit that as per the report received from the DEO, DEEO, Karimganj, no records relating to area salary of the petitioner are found. No service book relating of the petitioner is available in the office of the present headmaster of the school. Stop. On the other hand, learned counsel, on perusal of the petition, it is seen that the petitioner has enclosed extracts of the service book of the petitioner. Stop. Learned counsel for the petitioner, however, is unable to submit today as to the source of the extracts of the service book which are found to be enclosed to the writ petitioner. Accordingly, let the respondents bring their instructions on record by way of an affidavit, along with all reports of the DDO and other relevant documents. Stop. The writ petitioner will also apprise the court on the next date as to the source from where the extract of the service book, copies of the service book are enclosed to the writ petitioner as Annexure 1. Matter be listed again on 20 March. 20 March.
Well, kindly fix on before 20, actually 9, 20 they have
18 March.
Master.
May please, my lord, petitioner was appointed by annexion page 19, annexure 1, my lord.
Area salary.
My lord, I have not been paid anything right from my appointment. ma'am.
Yes.
So you have received
Mr. A. Fukan is for the GAD. Where is Mr. A. Fukan? Yes.
Lordship, in this matter, we are awaiting an instructions, Lordship. On the last occasion, we had been made a.
1 year, almost 1 year.
Uh,
Almost 1 year.
We have written, my lord, to the deputy, actually the appointing authority is the deputy commissioner.
Who represents the deputy commissioner?
I represent Lordship. After that, Lordship, what happened? We have returned to the government, Lordship, due to non-receipt of approval and budget provision from the government under so the circular for the post of Malasi, the wages could not be released from the set. So government is he. And second, Lordship, in regard to her regulation of service, as Malasi was forwarded to the commission secretary, BAD, there also we have forwarded.
You are the government council. You are supposed to represent the government.
Lordship,
I am the departmental counsel for the
I am
GAD.
DC. I am the agent.
He is the government.
I am the agent. He is the government.
But I am the departmental counsel.
In response, the government has requested to submit detailed proposal. He has requested us to submit the detailed proposal in terms of notification so and so of finance department.
So this proposal has been sent. Have you sent the proposal?
But the proposal could not be sent to the government as the applicant was engaged after the FRBM period, that is 1st September 2005. Copy of the government notification is next 10.
But for the my lord, I am for the my lord, my wages, my lord, whatever is there. The period I work, my lord, that I'll be sufficient. I have not come for any regulation or anything else, my lord. Neither I made a prayer for regulation.
Actually, there were two representatives. So one is for money and one is for regulation.
Let me give my.
Where is that FRBM notification? What basis?
Lordship, it is
19.
Yes, it's an extra and that is attached with her Paris Commerce, Lordship.
19/2005. 2005.
Finance for अपना 3rd October 2000
He was engaged. Who appointed him?
My lord, my appointment, lordship, will see at page 19. And
He is
I have
by the
been
deputy
appointed by
commissioner.
Deputy Commissioner, my lord, Shiv Sagar.
Then
My lord, I have not been paid any kind of my salary. Regarding that, my lord, page 21. They have asked
deputy
for
commissioner
the
will have to give the instructions properly. You have appointed him.
page 23 will be clear, my lord. Lordship, kindly have a look at the moment, my lord. Chetia is said to paid his salary wages due to non-evaluated budget under head number 2, wages major head account number so and so. I therefore request you kindly take necessary action in this regard. Then I made a several representation to the.
Yes, general administration and DC, get your instructions. We are not giving you another 6 months. We are giving you just 10 days time. If you don't give it, we are imposing cost.
I'll get my instruction.
Your instructions will
The
must,
challenges may not also been made to the PC, my lord, the.
I did not made any kind of challenge.
no,
my
no,
lord.
he's
I have
asking for
simply-
area salary.
Simply salary. my lord.
Area
Nothing
salary.
I have challenged anything.
And between the government and this agent, you are trying to shift the burden.
I'll get my instruction.
Yes, Mr. Government
So we have
Counsel.
already returned to them, Lordship. It is upon them, Lordship.
What do you mean you have written to them? Who has permitted the DC to make pass an appointment order? Is this appointment order as per law?
His appointment was temporarily engaged as Malasi, Lordship.
No, no. Who has authorized the DC? Show us under what rules the DC is engaged to authorized to appoint somebody.
Lordship, that is
Page 21.
an extra one.
Detention.
This is,
21.
On what basis? You see the last line, the engagement is warranted by urgent requirement of the kitchen in the circuit house.
Engagement is purely temporary, may be terminated at any time without assigning any reason thereof. No other allowances be admissible over the wages of Malasi. No pension or promotion benefits are permissible.
Very well, but at least you should pay him his wages. No other allowances will be admissible over the wages. You have not paid his wages. You are the appointing authority. You can't wash your hands and say that the government has not permitted. Who authorized you to make an appointment?
No, thing is, Lordship, question of budget, Lordship. We have to receive the budget from the government. So due to non-receipt of approval and budget provision from the
Mr.
government.
Counsel, see the order which has been passed here. You have engaged him on urgent basis.
Lordship, understand.
Who has
And-
authorized you?
And that is only in connection with the wages, Lordship, not above the wages.
No, no, does it say that? Very well, it's connection with the wages. You give the wages.
The budget has to be come, the waste, the amount of waste has to be, the budget has to come from them, Lordship.
No, that you have not specified in the appointment order. Wages of 5,000.
That is their, Lordship, I admit. From where the budget has to
Yeah.
come, everything.
You allow somebody to work and then say that, oh, budget has not come, I can't pay you.
Then I think, Lordship, question is not in regard to not paying, Lordship. We'll pay them, Lordship. Some delay may happen. Once we receive the budget,
Right
Lordship,
from-
Then you release the salary, you take, how much time do you require?
some update, let me get some updated
You
instruction in
release
regard to
the
the.
salary after 3 months, failing which you pay an interest.
Let me get some updated instruction, Lordship. Within that time frame, Lordship, he has to.
List on 18th, by which date the respondent counsel will obtain the required instructions in the matter. In respect of release of the area wages claimed by the writ petitioner. For rendering his service as a what?
There's a Malasi.
Malasi, Lordship.
As a what?
Malasi, my lord, page 19.
What is a Malasi?
Malasi is kind of, my lord, messenger type or cleaner type.
As a Malashi
In the circuit house.
in the circuit house of Sipsagar.
Malasi, first time.
More part, ways of 5,000.
Let the matter be listed on 18th.
Lordship, hearing this matter, Lordship, I have received the report based on which the impugn speaking order has been passed, Lordship. Lordship, may I be permitted to bring that on record by filing an additional.
Have we disallowed you to bring on record?
Lordship,
When did you receive it?
Lordship, it was received last night, Lordship. Otherwise, yeah.
Mr. D. Upamanyu, learned counsel appearing for the
Higher
higher education submits that he has received the instructions including what? The report
The report, Lordship,
received from
from the Director of Health
the
Service.
Director of Higher Education.
Assam.
He would like to bring it on affidavit. uh, Mr. S. Khaun, Learned Counsel, appears for the writ petitioner. Let the affidavit be filed within a period of 2 weeks.
Okay.
List on 18th.
Much obliged. Obliged.
18th.
Yeah, please.
Yes.
No, affidavit has been filed, my lord.
I'm appearing for the bank, my lord, because it's instructions. My lord, what happened actually in this case, my lord? The name of the petitioner in the PPO and the bank record differs. The two different names, my lord. So that is why the bank cannot release the pension, my lord. There's a mismatch. Either petitioner has to get his PPO rectified or he has to get his account rectified by submitting fresh KYC in the name of the new person, my lord. These are the two options available, my lord.
This is for family pension.
My lord.
We have been receiving, my lord, 1980, my lord.
Hmm?
Since 1980, we have been receiving, my lord. Suddenly in the year 2021, my lord, it has been.
But why was it stopped subsequently? Was there any change?
Because when he submitted his KYC, my lord, when he submitted his KYC and life certificate, which to submit, so then the matter came to light that his account name in the account where the pension is credited, that is different, and the PPO name is different, my lord.
What is the name in the account?
My lord, the account name is Khadija Khatun, and in the PPO it is Khudaza Khatun. We have informed the petitioner accordingly and asked him to get it corrected, my lord.
Who's the administrative? Which is the administrative department?
Department.
Home department.
Huh?
Home department.
Yes, what do you say?
At this stage, I have not received anything to say, Lordship.
Where will the records be? Pension department?
There are two PPOs, Lordship. One is with the bank, one half, and the other half is with the petitioner.
From home, Lordship, because he was working under as constable under SP. So from that, ultimately under home, Lordship.
Where is the bank? No, in the PPO, there is PPO, both the halves, there is no difficulty. The difficulty is in terms of the bank account.
Bank account, my lord. My lord, my instruction is that there are two options, my lord. Either he gets
Why is it not possible to get the account corrected? There is a form.
that he can get it corrected by submitting fresh KYC, my lord. Because if he wants to make his account
No,
in
not
the name
KYC.
of Khudaza Khatun,
Not KYC. The person has been drawing pension for last so many years.
my lord,
You have allowed her to draw pension.
my lord.
Now, according to the KYC submitted, there is some difference. So there is a form available in your bank where it says that both these two persons are one and the same person.
No, that is not possible because his name is recorded. Her name is recorded as one in the PPO, and another name is recorded in the bank account. And in the bank, while opening the bank account, the KYC which she submitted is also different, my lord. Because along with the life certificate, she has to submit the KYC also. The bank has told her either you get your bank account name changed by submitting fresh KYC, we'll change the name according to the PPO, we'll correct the name, but you have to submit with the KYC. That is the option available. Second option is available by she has to go to the department and get the supplementary the PPO issued by correcting her name.
What KYC was submitted? What documents were submitted in the KYC?
Page number 30, my lord. Life certificate.
What is your name?
Khadija, my lord.
Hadiza.
My lord, Khadija.
And what is the name reflected in the PPO?
Page number 31, my lord.
Khudaza.
31.
31, my lord.
Khudaza.
Name of family pensioner, my lord. Second column, my lord.
Hudaza.
Hudaza.
No, but this life certificate is submitted by whom? By the petitioner?
By the petitioner, my lord.
No, no, we are asking you what is there in the PPO, in your half of the PPO, what is the name?
My lord.
You don't know.
My lord, the page number 12, my lord. This is the relevant portion, my lord. Type portion.
You have typed it out from where?
From my lord,
Page number 13. It's a
My
type
lord.
copy of page 13.
page number 14, my lord. Original copy is with me, my lord.
Hmm?
Original copy is also with me, my lord.
Original?
Original copy of the PPO is also with me, my lord.
Page number 14 is not at all legible. Name is not legible. Page number 12 is a type copy of 14.
14, my lord. My lord, kindly see the original copy, my lord. This is here, my lord.
Yes, let us see. It's written as Khadija. And then in the bank account also it is written as Khadija.
No, no.
Account also Khadija, my lord.
But PPO it is named Hudaza.
Hmm?
PPO it is named Hudaza, my lord. No, the PPO that we have with the bank, my lord.
You verify this. I don't know. This says Khadija.
As far as it limit that the name in the PPO is Khadija Lossi. The only Lossi difficulty is the name that the bank has taken. And Lossi may kindly see para number 5 of the petition Lossi. Para number 5 of the petition. Petitioner begs to submit that her actual name is Khadija Khatun in all records, including her pension book. However, in the bank particulars, her name has been only written as Hudaza Khatun instead of Khadija Khatun. Petitioner does not know.
No, page 20 of the writ petition. What is this? Whose saving account? Whose saving account? Photocopy of saving account is this? Page 20?
Passbook, my lord.
Passbook. So
Passbook.
it's written as Khadija.
Khadija.
Then why is the bank objecting to it?
Well, as per the bank, PPO with the bank, as per the PPO which is there in the
You
bank.
produce that
the copy.
PPO copy.
My lord, we'll
You
file an
produce that
affidavit, my lord. I'll file an affidavit, my lord.
You produce the PPO.
My lord.
Heard learned counsel for parties. The dispute in this present petition is with regard to the name of the writ petitioner insofar as the documents, including the PPO, available with the writ petitioner is concerned. Name of the writ petitioner is shown as Hadiza Khatun. Stop. Whereas the bank authorities claim that the name of the petitioner is reflected as Hudaza.
Hudaza.
KHU.
KHUDAZA.
KHUDAZA. Hudaza Khatun in the PPO in the portion of the PPO available with the bank. Stop. Learned counsel appearing for the bank will produce the necessary records in support of the statements made. Parties are left to are given liberty to complete their pleadings, instructions and file pleadings if so required. List on 20.
Obliged.
My lord, there is no objection from the department for obtaining the BA degree, your lordship.
There is no objection.
No, lordship. There is no any rules also, your lordship.
So why do you say you are not allowed?
When I have approached before the authority concerned, they have denied, Lord. They not give the NOC, Lord.
Who has to give the NOC?
Inspector of schools. Lord.
But your instructions say that,
There is no objection, your
so
lordship.
let them give an NOC if there is no objection. Heard learned counsel for the party to this petition is filed by the petitioner, who is a postgraduate teacher in Kora Higher Secondary School. Petitioner during his service, petitioner was suspended because of after being taken into custody in a criminal matter. Petitioner is presently under suspension. Stop. It is submitted that the petitioner is undergoing B.Ed degree in the Lokhimpur Postgraduate Training College on deputation basis. However, because of his suspension from service, petitioner has not been allowed to attend the classes by the college authority.
Lord.
Stop. The petitioner has been informed that no objection certificate is necessary from the concerned authorities in view of the fact that he was suspended. He has been suspended from his service. Stop. Para. When the matter was called up, the learned standing council education was permitted to obtain instructions in the matter today. And the matter was called up in the second half. Stop. Learned Council, Standing Council, Education Department on instruction, verbal instruction received from the department submits that there is no objection insofar as the department is concerned in respect of the petitioner attending the B.Ed course. However, the petitioner's counsel submits that the department is not issuing any NOC permitting him to undergo a B.Ed course and attend the various programs undertaken by the college authorities as a part of the curriculum. Stop. One such program is scheduled on 1st of March, which is a community survey program. Stop. Learned Counsel to the petitioner submits that if the respondent authorities issued an NOC, then the petitioner will be permitted to attend these classes and participate in the community survey program scheduled on 1st of March. Stop. In view of the submissions of the Learned Standing Council, that there is no objection on the part of the department in the petitioner undergoing the course of B.Ed during his period of suspension, the respondent authorities, more particularly the inspector of schools, will issue the necessary no objection certificates and obligor any other such communication as required to the college authorities permitting the petitioner to undergo his B.Ed course during the period of suspension and take part in such other programs undertaken by the college authorities as a part of the curriculum for the B.Ed course. Since the community survey program is scheduled on 29th of March. Sorry, 1st of March.
1st of March.
The respondent authorities are directed to issue the necessary NOCs reflecting their no objection expeditiously so that the petitioner can attend the program by 1st of March. With the above observation, writ petition stands disposed of. Copy of this order be furnished before the respondent authority, enabling them to carry out the directions as passed by this court. Writ petition disposed of. এটু মারি report করে। Affidavit not filed.
Lordship, that by yesterday I received it lately. I served them a copy but couldn't file it. But Lordship, while going through it, there is some mistake, Lordship. I have to recast it in the night while going through it. That's why,
They
Lordship.
served you a copy.
Yesterday I received at about 2:30, Lordship, in the evening.
Mistake about?
Mistake. Correct. No, no, আপনি
Mistake about?
এখানে ভালো করা নাই, কাল করে দিই।
When can you file it?
Lordship, by next week I will file it, Lordship.
Well,
Lordship,
when they are filing it, my lord, your lordship may kindly, in the one notification they are mentioning here also, that the application was rejected. Earlier also, the same communication was there, same number they are mentioning earlier one also. Now, in paragraph.
No, but that is not filed, so
No, my lord.
we can't take a judicial notice as yet.
No, I can say, my lord, the earlier, the affiliate which was there, so that said that, my lord, the it has been rejected. Same communication has been mentioned here. So on the last occasion, next occasion, when it comes, my lord, either they may produce the records on the next occasion also.
Lordship, my instruction is that in the rejection, Lordship, many industries names were the same letter.
You produce it.
Yes, Lordship.
Whatever is there, you produce it.
Yes, Lordship. I will
Correct on
annex with the affidavit, Lordship.
Let them annex it, my lord.
When can you file it? Give a fixed date.
Lordship, by next week I will file it, Lordship, fix it up on 20 or 19, Lordship.
If you are filing next week, then why do we defer the matter so long?
Only recasting is to be done, no? Nothing.
You file it by 5th.
Lordship, can it be on 6th or 7th, Lordship?
Let him file it by 7th. Heard learned counsel to the parties, the counsel to the respondents. Pray for further time to file their affidavit. In which writ petition?
WPC, my lord, they are filing it in WPC.
Lordship, 1607 as well as 2068 and.
You are filing in all these writ petitions or only one?
2068, Lordship, some factual part are different. That's
How many affidavits are you filing?
Lordship, in all of the cases.
Filing the affidavits. Let the matter be listed. Let it be listed on 7. We'll see. We'll fix a date after
7th,
that.
my lord, I will not be there.
Okay.
So, my lord, if you lordship may submit, my lord, on 11th, my lord.
No, it's only a question of filing the affidavit. So let us have it on 7. Let them file the affidavit if they say, so that we know the status, because we have already proceeded for hearing now. List on 7th, Dr. Saraf, assisted by Mr. P. Purwa, appears in all the writ petition. Mr. Kolita for industries. Mr. P. Chaudhary for the respondents. 7th, list on 7th.
Lordship, I'm appearing on behalf of the respondent number 8 and 9, Your Lordship. Lordship, if I may be allowed to place the facts once again in brief, Your Lordship, because the petitioner is claiming for benefits of
We will
petition.
try to dispose of this matter
Yes, Your
today.
Lordship.
So
Yes,
let us take it at the end of the list. Unless there is some difficulty. We'll take it up at the end of the list because we'd like to pass an order if possible today itself. Five zero.
May I plead your lordship? Lordship, matter pertains to the non-payment of area salary lordship. Last occasion, respondent was directed to obtain it.
Lordship, I have an instruction, Lordship. The director has already instructed the DO and the DO is processing, Lordship, because certain documents are required to be furnished. And once that documents along with the proposal is received by the director, they will process it for further, forward it to the
Who
government.
will process it? Who's the last order proposal from DEO not received?
Not received, Lordship.
Till
And
date not received.
again on 27th, Lordship, of this month, Lordship, the communication will be made to the DO to urgently furnish the proposal along with the relevant documents, including the non-drawal certificate, Lordship.
Why has it not been given?
And as per telephonic instruction, Lordship, the DU has informed me that they are processing it because these documents are required, non-drawal certificates to be issued from the Treasury Office. So they will be processing it and furnish it to the Director's Office. Lordship will fix after 3 weeks, Lordship. Perhaps in the meantime, it will be received by the Director and the Director Office will onward forward it to the Office of the Secretary for necessary sanction. So that proposal is yet to be received from the DEO, Lordship. Even on 27th of this month, the communication has made to the reminders has been made to the DEO. Now, admittedly, Lordship, the petitioner is getting the current salary from 9th June 2023. Sorry, from June 2023. Only that area part, Lordship, from 4/11/2020 to May 2023.
Mr. P. N. Sharma, Learned Standing Council, renews his submission that renews his prayer for further time as the instructions sought for, as the proposal sought for from the DEO has not yet been released. DEO Morigaon. Stop. Mr. What is your name?
M. Dekal.
M. Deka appears for the writ petition. Since this is a the grievance of the writ petitioner relates to area salary. Let the DEO furnish the proposal as called for before the next date fixed. If the proposal as called for is not furnished, consequential orders may be passed. Just on 11th
What?
March.
11 March.
11.
Lordship, here I pray for 2 weeks time, Lordship. Instruction, although is received, Lordship, complete instruction was not there, so I am going to file affidavit, Lordship.
2 weeks further time is prayed for is granted to the Learned Council for the elementary education, Mr. P. N. Sharma. Mr. M. Khan does not object to the prayer. However, he submits that the interim order passed earlier be extended till the next date fixed. Placed on 15th of March. Interim order passed earlier will continue till the next date fixed.
The matter pertains to the non-payment of non-issuing of the family pension and other pension with benefit. What happened in this case, the petitioner was retired from service as a get for employee. After his pension.
Yes, instructions.
Lordship, as per respondent number 5 is concerned, Lordship, instruction is still awaited, Lordship. We have received some instruction, but that is not enough, Lordship.
May I ask you
Some
one
more
thing,
time may be
if
granted,
lordship may directed to the respondent of 5 and 6 to process the pension proposal of the petitioner and send to the AG for releasing the other benefit like is DCRG, GIS and the TPFM. So provisional pension I have
Instruction
received.
respondent number 5 is awaited, Lordship. That some more time may be granted, Lordship.
Only this person, if they have sent a proposal to the AG, then the whole thing will be solved. Because the proposal was sent by the additional Assistant Labor Commissioner Business Sariali on 5th of October 21. It is on page 39 and page 40. So the Assistant Labor Commissioner had done his job. Now it is pending before the Labor Commissioner Assam, Gopinath Nagar. It is on page 39. So all requisites formalities are done and they have sent for releasing the amount. So nothing has been done here.
Who is supposed to give you the proposal?
Proposal by the Labor Commission. It is on respond number 5.
Further 2 weeks' time granted to the government council to complete her instructions
Lordship.
and call for the proposal for
Respond number 5, Labor Commission Assam.
for pension.
Pension, Lordship.
Pension proposal from the
Family
respondent
pension
of
and
5
GPF.
Labor Commissioner.
GPF also.
Pension and other retirement benefits from the Labor Commissioner, Assam. It is submitted by the government council that the instructions also called for have not yet been received. Let the matter be listed on 15th March, by which date it is expected that the respondents will complete their instructions, failing which consequential orders may be passed by this court. Mr. A. Chetri appears for the writ petitioner. List on 15, MS
And Hussein.
M. Hussain.
And Hussein.
N. Hussain appears for Accountant General.
Deeply obliged, Lordship.
Yeah, please, Lordship, matter is regarding suspension, Lordship. So last occasion, the standing council has taken time to.
Yes.
On the last occasion, Lordship has directed us to obtain instruction as to whether the SOCAS has been issued or not, Lordship. Now, on 30th of January 2024, the SOCAS has been issued under Rule 9 of the Assam Service Disciplinary Appeal Rule 1964, Lordship. That SOCAS.
Where is the suspension order?
Suspension of the Lordship, page 42, Lordship. Lordship, allegation is that the petitioner physically assaulted one of his colleagues and students and on 1/9/2020 during school hours, Lordship. Lordship, after receiving SOCAS notice, we have filed a reply, Lordship, on 9th February, Lordship. Thereafter, Lordship, some process has been going on, Lordship, as per information received from the office, Lordship.
And the petitioner is getting subsistence allowance, Lordship.
reply দিছে? Spoken reply দিছে?
When was the show cause issued?
So cause notice was issued on Lordship 30 January, Lordship.
30th of January.
January, Lordship, we have replied on 9th February, Lordship.
You are receiving your subsistence allowance.
Lordship, by the office letter dated 13 January, the Director of Elementary Education have sent a letter to the DO to regarding vacancy position of the assistant teacher in the Nagaon district, Lordship. Thereafter, by letter dated 19 to 2014, Lordship, DO Lordship sent a vacancy position to the Director of Elementary Education.
No, you are now required to, the proceedings have been initiated against you.
Lordship.
Your prayer is for what? Setting aside the suspension.
Setting aside and reinstate the petitioner, Lordship.
So that will examine the matter. Meanwhile, your subsistence allowance have been paid.
Lordship.
It is submitted by the learned counsel for the petitioner that the prayer in the writ petition is for setting aside the suspension order and the direction to reinstate the writ petitioner in his service as what? Assistant
teacher, Lordship.
Of Bamuni ME School.
Lord.
Stop. Petitioner was suspended with effect from we suspended by the impugned order dated 11th October 2023. It is submitted that since there was no review of continuation of suspension nor issuance of show cause notice within the period specified, within a period of 3 months, the suspension is required to be interfered with and set aside. Era Mr. P.N. Sharma, learned standing counsel elementary, submits that the show cause notice has been issued on 30th January 2024 and the inquiry proceedings against the writ petitioner are underway. He, however, does not have any instructions with regard to whether any review or continuation of suspension of the writ petitioner was undertaken. Where let the respondents complete their instructions and file necessary affidavit. Matter will be posted after 2 weeks. After 3 weeks, it is submitted that petitioner has been granted his subsistence allowance. You are receiving it as per provision. Let the matter be listed after 2 weeks. 2 weeks. Date 15th of March. Yes.
Please, Lord.
Yes.
Petitioner, my lord, challenging the suspension order as well as my lord, my lord, discriminatory treatment against the petitioner, my lord. Whereas rules, my lord, do not follow, my lord. Whereas same promotion order, my lord, others has been followed, my lord. My lord, because of that, my lord, due to preventive by sufficient cause, my lord, petitioner is unable to join in his place of promotion, my lord. And others, same promotion order, others are given, have been there considered, my lord, considered by his application, but without
Yes,
considering
he is
me, my
appearing
lord.
for the respondents.
Lordship, I'm appearing for respondent number 5.
My lord, rule 6.
No, who's for the finance? Finance department? Yes.
And the instructions are awaited again.
Page 64, my lord, there's a rule, my lord, 63, my lord.
Lordship will grant us some further time, my lord. At least 10 days time.
Page 64, my lord. Para 18, my lord, serial number 18, my lord. Page 64, my lord. Joining time a person shall join within 15 days from the date of receipt of the order of the appointment or promotion, failing which the appointment shall be cancelled unless the appointing authority extend the period, which shall not in any case exceeding 3 months time. Immediately I file a petition representation without
Where is your order of transfer or promotion? Where is
promotion, my lord, annexure 1, my lord,
Annexure
page
1?
29, my lord. My name is serial number, my lord. 53, page 33, my lord. Moran to Thingkong, my lord. Irrigation Department.
53.
33, my lord. 33. Serial number 53.
53.
Serial number
Three.
53.
53.
Serial number, my lord.
Yes.
My name is Nabakesh Goswami, my lord.
Huh.
And I was promoted on promotion transfer Moran Thingkong Irrigation Division, my lord.
Hmm.
And my lord, day after, my lord, I immediately file a petition, page annexure 3, page 39, my lord.
Hmm.
Due to my mother is my old age and a medical problem, and my lord, they did not consider. In the meantime, my daughter also serious, my lord, page 41, my lord, in hospitalized, and due to
So you
death,
did not join?
did not join, my lord.
Huh.
And my lord, thereafter, my lord, page thereafter in common order has been passed on page 56 to non-compliance of this direction shall be viewed seriously. It is a common order, my lord. Immediately another pair of petition was given, annexure 6, page 57, without considering date, my lord. And similar person was considered page 58, my lord. Same promotion order, page 58. This promotion order was modified, my lord. Same promotion order, my lord. Jotin Chandra Kolita and Urbosi Rahang, my lord. And my lord, my case was not considered, and they issued me a suspension order by giving show cause. Suspension page 60, my lord. 9/10/2020.
They are not obliged to consider your prayer because on what ground? You have been given an order on promotion.
My lord.
You did not go and join.
Yes, my lord.
It's one
They
thing
have to give an at least, my lord, 30 days or 3 months. There is a provision, my lord, for rule, my lord. Rule left already page 64, my lord.
For how many months?
Rule page 64, my lord.
64.
Not exceeding 3 months. Minimum, my lord, that should be
Not
considered.
exceeding 3 months.
But
So
they
you are-
similar same promotion, others were discriminatory treatment to me.
Where is the suspension order?
Suspension pays, my lord, 60, my lord.
60.
And thereafter, my lord, they issued show cause, my lord, and same day appointing authority was presenting officer was appointed same day, my lord.
So 30th June is the order of promotion.
Yes.
3 months will expire when?
Yeah, in December here.
July, August, September.
Yes, at least, my lord.
30th September.
But they should, my lord, show cause, my lord. So, my lord, my case will consider, my lord. Without considering me, at least have to consider without considering.
Maybe considered, not considered,
And
but as a
my lord, so cause was issued for
unless there is a stay, you have not prayed for a stay of the transfer or promotion order.
Promotion.
There is no stay.
My lord.
This order continues. You are supposed to go comply with this order and join. It is one thing to say that you have joined and thereafter you have filed some application saying that because of this hardship, that hardship, you want to be on leave or you want a modification of the transfer order, but you refuse to join.
Now the so cause was issued,
Of
my lord.
course.
So cause was issued, my lord. So there is a, my lord, illegality is there, my lord. Please, may kindly see. Charge sheet, page 68, my lord. Page 68. Annexure 13, my lord. They last para before, you are therefore charged with disobedience and non-compliance with the government order, lack of integrity and serious misconduct on your part. You should submit your written statement in defense within 7 days on the date of receipt of the communication. This order was passed on 5/12/2013, my lord. Same day, my lord, presenting officer was appointed, my lord, 5/12/2000. That means, my lord, they predetermined to act of the adversely against me, my lord. My representation was that thereafter I file also reply, my lord. They did not consider me, my lord.
Lordship will see
At
the,
least
my lord,
consider me.
68, my lord, the third para. Whereas you were issued a show cause notice dated
You
11
submitted a reply.
Yes, madam.
So
My lord,
the-
before my lord, without giving the 7 days, at least without predetermined by day, my lord.
you were issued a show, you were issued some, you were issued a show cause notice
Show cause notice.
on 11/8.
Yes.
8. No, 5, my lord. 5/12.
নহয়, নহয়, আপুনি ওপৰৰ পেৰাটো কওক। আচ্ছা। Same page.
Okay. See, first show cause notice you issued him at 11/8.
Preliminary, my lord, it will be.
Whatever,
every time
but
there,
he is
yes.
entitled to 3 months protection.
Lordship.
11/8 is not 3 months. It was, promotion order was given in June.
June, yes,
So June means July, August, September it will end.
yes.
So before expiry of 3 months, you issued a notice.
No, no, my lord, the rule says, my lord, may I read it, my lord? The rule says subject to extension by the government. Here, government has not extended it, my lord. From the very conduct of the government of by issuing that, my lord,
No,
particular
there
show
is no
cause,
considerment.
failing which appointment shall be cancelled unless the appointing authority extends the period. It has not been extended, that's why.
Same
show cause, my
promotion,
lord.
others were considered, my lord.
That's a different issue, my lord.
My lord, why
Where-
are you going to
Where is the
discriminate,
rule?
my lord?
Where is the rule again?
Rule
Page
64, my lord, page 64.
64.
64, 18, my lord, rule 18.
15 days.
15 days from the date of receipt order, appointment or promotion, failing with the appointment shall be cancelled, my lord.
Unless the appointing authority extends the period, which shall not in any case exceed 3 months.
You file your response.
My lord, I will file my lord.
Or
File
it
your
will be
response.
given to join in any place I am going now, my lord. All are at recovered, my lord.
You can't bargain like this and that too before the court.
Consider,
Consider what?
they may consider, my lord.
They
did
may
not
consider, they may not consider. You have to show us you did not go and join in that order place of posting. If it is a case that circumstances were
Now,
so
my
severe,
lord, I cannot join because I am suspended, my lord.
of course now you can't join. You are suspended because you did not join.
Yes, man.
Heard learned counsel for the parties, Mr. B. Gogoi, learned standing counsel finance is
1, 2,
permitted.
3, and 4.
Huh?
Finance, my lord, yes,
Notice
we are
was
the main
issued
authority.
already.
Yes, already.
Notice was
Is
issued.
permitted 3 weeks time
Well,
to file the affidavit in response to the contentions raised in the writ petition.
no,
The petitioner, he released all his subsistence allowance in the meantime and all other dues payable under the rules. List after 3 weeks. If you
And
want a
within
date, we
3
can.
months
give a date.
also, they did not review also in my case.
Mhm.
Within 3 months, they also not.
It is also made clear that pendency of the writ petition shall not be a bar
my lord,
to consider the prayer of the writ petitioner for change of posting
or reinstatement.
or reinstatement on the basis of the representations filed with the writ petition
Right.
in the meantime.
Mark.
God bless you.
Lordship, we have received instruction, Lordship. We have received instruction, Lordship, and the department proceeding has been initiated, Lordship.
File your affidavits.
Lordship.
Let them file, bring it on record.
But Lordship, unfortunately, by tomorrow I'm going to be retired, Lord. Therefore, Lordship.
What can be done today? You want me to set aside?
Yes, Lordship.
On what ground?
Your Lordship's proper judgment, Your Lordship, that is order. The similar case, yes, Lordship has already passed an order. And Ajay Kumar Chaudhary, Lordship. Even Lordship,
That order we can pass it after you retire also. Let them complete their pleadings on record.
Lordship is today.
When were you
I will get opportunity, Lordship, for immediately, Lordship, my father pensionary benefit as well as retirement benefit. It will be helpful for us, Lordship.
Naturally.
Therefore, Lordship, in the last stage, Lordship,
What is your ground? What are your grounds?
Lordship, the criminal case has been filed against me and the learned trial court has granted bail. I have supported the same before. This one I will give, Lordship. I even also opposed before the authority placing the reliable document, Lordship. So Lordship, even Lordship. So, Lordship, can you be clear to Lordship? 2-1, Lordship. Rule 6, Lordship clearly mentioned that, Lordship, that the charges and statement of allegation should be served within 3 months from the date of suspension, failing which government servant concerned should be reinstated. So, Lordship, what is the bar, Lordship, to reinstate me, Lordship, in my respective post? So that is the fault of the government, Lordship, and
When are you retiring?
Lordship, by tomorrow I am going to retire.
Then the suspension is irrelevant. You'll retire anyway.
Yes.
But regarding whether they can withhold your pension or not is an issue to be decided in terms of the pension code.
But if Lordship has passed this order today, Lordship, I will get.
How will you
advantage,
get?
Lordship.
Because there is a criminal proceeding against you.
Every month it is admitted that, Lordship, criminal proceeding may be pending, Lordship, but if the search has been framed, Lordship, and I will be convicted, that I may be terminated in any point of time.
How?
Lordship.
You're retiring from tomorrow.
By tomorrow, Lord. I am
Then
going
how
to
will
be
you be
retired.
terminated later?
So, Lordship, the pendency of the criminal proceeding, it shall not be barred,
Have you
Lordship.
seen the pension code? Have you seen Rule 21, 22? Please go through it. The submissions you are making, you cannot make in view of Rule 21 and 22.
Pension law.
So merely setting aside your suspension will not entitle you to a pension, but of course you are entitled to provisional pension,
Yes, Lord. And other retirement benefit, Lord.
other retirement
I
benefits
have
that they will
already-
process. Well, what do you want? You have not challenged the
to the-
DP.
Yes, I have not challenged DP. I have already only challenged the suspension order, Lordship, on basis of the Rule 2-1, Lordship. I am entitled to get such relief. And your Lordship, similar cases, your Lordship has passed the order.
You are not. You read pension code and come back tomorrow. You read it
Yes.
day after, on first. List on first.
Kindly of.
Keep your blessed.
At the request of management.
It was the lordship. On the last occasion, lordship, respondent was supposed to file the affidavit, lord.
The extra copy is not being received by us, Lordship. Therefore, we cannot take the instruction. We have not been served by extra copy.
It is submitted by the Standing Council, Mr. R.S. Ronghang, appearing for the Karbi Anglong Autonomous Council. Extra copies have not been furnished to the council by the council for the petitioner. Stop. The learned counsel for the petitioner will furnish extra copies. Within the course of this week,
Within course of the day, lord.
and the respondent is permitted to complete his instructions and file necessary affidavit if so advised.
Lordship, kindly fix a date, lord.
Released on 15th March.
Obliged.
The transfer matter, my lord, where where I was praying for a similar order, giving liberty to take action if necessary, my lord, provided it is recommended by the committee. It was transferred on page 17, my lord.
Which order you are praying for?
Order at page 21. Same,
21.
22, my lord.
22. Same order.
Same only.
Yes. You are transferred by which order?
By order dated 17, page 17.
Page 70. Then you
Then, my lord, it is not, it is in violation of that committee rule. She has not been transferred in compliance of that rule, my lord. Rule 5. it has to be a committee, my lord, that page 22, I've stated, my lord, that Assam Secondary Education, Elementary and Secondary Education Regulations of Posting and Transfer Act 2020. Under this, my lord, there is a committee. Committee, my lord, transfers the petition. A teacher. Liberty was given to take action if necessary, as per the act.
Okay, heard disposed, page 22. Page 22. Heard senior counsel, Mr. B.D. Das, assisted by Mr. D. Thousand. And Mr.
C. Sharma.
C. Sharma on behalf of RM Das.
No, Lordship, I have the standing counsel.
Okay, standing counsel, NC Hills.
Yes.
Disposed. Yes.
May I please, Lord? But the last occasion, it was directed to obtain instruction, my lord, 29/1/2024, my lord.
Lordship, we have received the instruction in this regard. In this regard, we have received the instruction that search sheet was filed in this particular case, and that the city is along with the court, Lordship.
You're not supposed to submit the CD. Are you supposed to submit?
No, only the.
Huh? So you get the CD. See, the allegation is he has violated.
Yes,
He has broken the conditions. It is for you to say whether he has done it or not done. What is he has filed some complaint.
Lordship.
Why have you not done it? We call for the OC.
Lordship.
This kind of evasive answers will not do. There is an allegation that he has misused the conditions, the liberty granted. You have to give us this information.
Lordship.
You can't give a lame excuse that the CD has been furnished. Who is the officer in OC? You get instructions from the OC straight away, if not from the SP concerned.
Lordship.
We want it by the next day.
Lordship, CS number was provided in this regard, Lordship, whether.
CS is a different issue.
Yes, Lordship.
CS is a different issue.
Yes, Lord.
We'll cancel the bail, let him go and appear before the authority concerned.
Lordship.
The competent court.
Lordship.
But you have to tell us that the conditions are violated, not violated, what information you have.
Yes.
We are supposed to look into it. This is a application file.
Yes, Lord.
We can't close this application on the basis that the CD has been submitted.
Lord.
When can you get it?
Lordship, need a week, Lordship. For a week, Lordship. From Dibrugarh, Lordship.
Wherever it is, how are we concerned? Why do you mention the places?
Lord.
How are we concerned? We are concerned with the information whether he has violated the conditions.
Lord.
Or he is trying to stifle the investigation.
Lord.
We are putting you to notice. If we don't get it by next day, we are calling for the SP.
Lord.
Learned APP submits that he further time be granted to him to complete his instructions in the matter. Let the matter be posted again on after 1 week.
Obliged.
Mr. So-and-so appears for the writ petition. You are appearing for the private respondent. What is your name?
M. Dekala.
Please
On
give it.
behalf of ASAP.
Yes.
May I please your lordship? Lordship, in this matter, we want to file our reply.
At the request of counsel for the petitioner, matter stands adjourned for 2 weeks,
2 weeks.
enabling them to file their reply. MSD Mushari appears for the
Secondary.
respondent, secondary education department.
Obliged.
Yes, what is the IA for?
I for setting aside abatement, my lord.
Oh,
I, my lord, 196 of 24. And my lord,
any objections?
no, lord.
No objections. This IA is filed for setting aside the abatement of the connected writ petition
Lord.
being WPC 5343, which was abated in view of the death of the writ petitioner.
Writ petition.
But is there an order passed for abatement in the writ petition?
My lord, actually, there is delay. And for that, my lord, the delay has already been condoned, my lord.
No, no, but was there an order for abatement passed?
But there is an action for all filing of.
There is no order. The last order in the writ petition is 22/8.
Lordship. 20.
Is there any other order passed?
Lordship 27/9/23.
27, 27/9/23, Lordship.
In the writ petition?
Lordship, I think in the miscase.
Writ petition.
Writ petition, Lord.
27/9?
27/9/23.
No, there is an order here of 22. Hasn't it yet? 27/9, second file.
Main case. There is direction for filing abatement petition.
There is no order yet.
In the writ petition.
No, last order is 22/8/2022.
Well, the delay was condoned on 13/9/23.
Thereafter, it was
My lord, the direction on 27/9/23 for filing an
What is the writ petition number?
Well, the 5343.
5343.
The one, this is the
22.
You have a look, it is not there. Have you-
Delay condoned, okay.
Oh. Itu better pitch कैसे रहते हैं? Pitch कैसे ले रहे हैं? Mistakes नहीं होगा.
1441%. 1441%.
Oh, itu ठीक होगा. Itu जो है पाकिस्तान question. कितना?
Mistake out of lane. It is 2241. 2241. 2242. 2242. Yes. 2242. Mistake. 2242.
2242.
That has been disposed of.
No, no, this is for a condonation of delay of for substitution.
This actually petition is for my lord setting aside abatement and condonation of delay.
Huh?
But the delay has been condoned, but abatement has not been set aside.
But where is the order of abatement?
Secondly, on my lord, 27/9/23. Order has been passed.
Huh?
27/9/23, my lord, order has been passed. But in which
Where it was listed before the Honorable Justice, not SK made here.
It is not here.
maybe it is passed to link here. 2241 of passed to link.
I think I
224.
27/9.
2241. 2241 mistake. 2241 is for my lord the substitution miscase.
আমার মূল লেখা আছে
I am asking you, where is the order by which the showing that it has got abated? There's no order. You check up properly.
My lord, when there is my lord delay, my lord, in filing, my lord, matter has already been abated, my lord, because of that, my lord. Because there was delay of 56 days, my lord, in
No,
filing,
no,
my
no,
lord,
but there has to be
substitution
some finding by the court that in view of this provision, the writ petition has already abated. No such finding is there.
Lordship on 27/9/23, my lord, that petitioner was the my lord, pray for my lord some time to gun through file, my lord.
That is there.
That
my
is
lord. It is there, my lord. That is on the basis of, my lord, the note in here, my lord, by the, my lord, the office, my lord. Because of that, my lord, this honorable court has earlier passed this order for filing the, asked me to file, say, setting aside the application for setting aside abatement, my lord, by the order dated 27/9, my lord. Abatement petition is required.
Okay, then we do one thing. We send the matter to the registry to make proper note as to.
No, lordship may do that, my lord. On the day, my lord, when this, my lord, petition for this, my lord, the
What you have-
limitation has come up before this honorable
No,
court.
what
my
I am
lord.
saying is, this is a calculation given by the
Lordship.
registry.
Lordship.
Pursuant to this, there has to be an order.
Order, my lord, the thing is that, my lord, on the day when, my lord, substitution petition has come up before this honorable court on 27/9. My lord, this honorable court has gone through this note. And, my lord, after going through, asked me to file an abatement petition. And because of that, my lord, it has happened, my lord.
13/9/23, my lord, that delay has been condoned.
Delay has been condoned on that day. Actually, my lord, on the day of the condonation of delay, my lord, the abatement should have been set aside, my lord. But that part has been left out, my lord. Technical, my lord.
Which is the application for setting aside abatement?
My lord, initially this is, my lord, the 2242.
242.
2242.
I know.
I. 2242, 23.
24.
Yes, I could not file the, my lord, substitution petition within the time frame that is 150 days from date of the appellant. My lord, this, my lord, the abatement has come, my lord. Matter has been abated because, my lord, I have not filed the substitution petition within time of 150 days, my lord. So I have filed the, my lord, abatement and for the condonation of delay of 56 days.
That delay has been condoned.
That delay has
Only
been
been
condoned, my lord. But the abatement part remains, my lord.
Heard learned counsel to the parties in view of the order dated 13/9/2023, by which the delay of 56 days in filing the substitution petition stood condoned, comma, the abatement which is set aside by operation of law in due to the death of the writ petitioner in WPC 5343 of 2022 stands the abatement which is set in by operation of law in WPC so and so will not be operative in view of the order passed in IA number 2242 of 2023 dated 13/9/2023 condoning the delay of 56 days in filing the substitution petition. Stop. Now petitioners have also been substituted.
This, my lord, I, my lord, 224123, my lord.
Stop. IA accordingly stands disposed of. Then come to IA number 2242.
41.
2241. In IA number 2241, application has been filed seeking substitution of the legal heirs of the applicant, legal heirs of the petitioner, late Gojendra Pathak, by the present applicants who claim to be the
Priyam Pathak.
only the wife,
man.
only the spouse or wife of late Gojendra Pathak to be the legal heir. Stop. Accordingly, no objection being raised by the respective respondent councils, the IA stands allowed. Srimati Priyam Pathak is substituted in place of late Gojendra Pathak. Is substituted upon the death of late Gojendra Pathak in WPC number so and so. The applicant will file amended course title before the registry within 2 weeks from today. Writ petition number 5343 be listed upon necessary endorsements being made by the registry upon receipt of amended course title to be filed by the applicant writ petition as directed. Both the I's are disposed of. Writ petition directed to be listed on after 2 weeks.
The service report on respondent number 5 is awaited.
Are on service report of respondent 5. Who is respondent 5?
My lord, it is the place to which the office to inquire stands for the principal VTRC, Parama. Lordship, I have the
You are not appearing.
No, Lordship.
Hmm?
Principal VTRC, Lordship, it has to go by post. Lordship, I am having the instruction, Lordship.
What is that instruction? Tell us.
Lordship, basically it's that the in the office to maintain the congenial atmosphere of the office, Lordship, he has been transferred. He has been hurriedly won many times. Lordship.
He is not found congenial. You bring it on record.
Bring it on record. Yes, Lordship, because the Anganwadi workers and helpers have given complaint, Lordship, that is written.
Bring it on record.
Yes, ma'am.
Matter be listed after 2 weeks. Meanwhile, the respondents may complete their instructions and file necessary affidavit if so advised. List after 3 weeks.
Interim order continued.
Interim order. Oh, there is an interim order.
My lord, there was an interim order.
Suspending the transfer.
My lord.
Then
Because
it has
there
to
was no other.
be on a fixed date. Then when can you file it?
Lordship, let it be on 13.
13.
Yes.
Matter will be listed again on 13 interim order. 13 March. Interim order passed early will continue till the next date list.
Obliged.
May I please? Chief, there is a office note, my lord, in respect of respondent number 3, my lord. Which shows, my lord,
Shows what?
unserved notice has not been received yet, my lord, and also, my lord, there is a direction, my lord, to place the,
Fresh steps. You take fresh steps.
my lord, the Pharmacy Council of India, my lord, which, my lord, have taken steps, my lord, but no, my lord. Online, I also checked out, my lord, this is the, my lord, address, my lord.
Yeah, what can we do? You find out where the address is, a proper address. From where can we find out? You find out the proper address.
Through online, my lord, I have checked, my lord, this same address.
Then you
my
take
lord.
fresh steps on respondent number 3 to be taken by the writ petitioner within a period of 2 weeks from today.
But CGSC otherwise used to appear. In some cases, my lord, they have accepted notice.
Who?
Central government standing on.
You find out from CGC.
Yes, at least you can try, my lord.
Okay, then I'll try.
Alternatively, my lord,
The
you can, my lord,
petitioner may
approach
also serve copies on the CGC, Guwahati High Court. If the CGC, if the office of the DSGI considers it appropriate to, may consider representing the respondent number 3.
Yes.
List after 2 weeks. Mr. B. Gogoi for the Pharmacy Council.
My lord, no. My lord, for the health department.
Health Department, Government of Assam.
My-
Yes,
Look, next item, my lord, same.
Same, my lord.
similar order after 2 weeks.
Obliged.
May it please your lordship. Lordship, in this case, I have challenged the mutual transfer order, lordship. And
Someone
subsequent,
has filed an IA.
yes, lordship, subsequently I have filed one IA as because, lordship, my salary was not paid by the respondents, lordship. Since 3 months, I am not getting any salary, lordship.
Issue notice, returnable 2 weeks. MS D. Mushahari appears for,
Lordship, Mr. P.N. Sharma.
P.N. Sharma appears for elementary education.
Lord.
Steps on respondent 6 by registered post and usual course within 1 week from today. Pendency of the IA shall not be a bar for release of the current and area salary
Lord.
of the writ petitioner.
Lord.
Extra copies
Any-
will be furnished to the standing council within a
Lordship,
period of
any
1 week.
fixed date, lordship?
Hmm?
Date,
15th of March.
Lord.
Yes. And in the writ petition,
And writ petition, lordship, we have taken step to the private respondent again, and that was sent to the respondent on 23/2 only. So 15 till 15 March, lordship, already we have taken step, lordship. As per office note dated 26/2/2024. lordship. Others are representing. Obliged.
Obliged.
Dr. Python 63, I am appearing for the private respondents 8 and 9, your lordship. Dr. I would like to place the facts in brief once again, your lordship.
facts are not in dispute. It's a question of the interpretation of the rules.
Yes, your lordship. Lordship, I just want to place the facts
Yes,
because
yes.
the petitioner is claiming benefits in the same year of promotion as he has acquired his qualification also, your lordship. But just in brief, your lordship, the respondent 8 and 9, they were appointed in 1990 and 1997. Thereafter, they were transferred in 2003 And thereafter, an option for enlistment was also provided. That was in 2011. And accordingly, the gradation list of 31/5/2013 was released. There, the petitioner, the respondent's name were in serial number 20 and 21. And since there was no objection, and thereafter there was a bifurcation, certain persons had transferred because of the bifurcation. That's why the respondent's name was bumped up to 15 and 16, Your Lordship. Lordship, at this stage, Rule 24(2) has been fulfilled regarding being placed at the bottom of the list, Your Lordship. Whether we go by the 2002 amendment rules or the 2014 amendment rules, Your Lordship. Thereafter, Your Lordship, then the petitioner had, at this time, Your Lordship, from 1/12/2013 to 28/2/2014, Your Lordship, the petitioners were undergoing the departmental training, which is an admitted fact in their writ petition, Your Lordship. Thereafter, the results were declared on 16/9/2014, and on 10/10/2014, the minutes of the meeting was submitted. And on 21/10/2014, the respondent number 8 and 9 were promoted. Now, the contention of the petitioner is that the benefits of the promotion, regarding the benefits of the promotion in the same year as he acquired the qualification. Therefore, Your Lordship, I would like to take you back to the rules, Your Lordship. Rule 2H, Your Lordship, it defines the year as an English year, Your Lordship. That is in
Which
page
rule?
150, Your Lordship.
Which rule?
Rule 2H, definition, Your Lordship.
No,
Page-
which rules of which year?
Lordship, 1993 rule.
93.
Page 150 of the rejoinder, Your Lordship. Internal page 71.
Okay, rule number
2H, Your Lordship, the definition, Your Lordship.
2H,
2H.
year.
Year means English calendar year, Your Lordship.
Yes.
Thereafter, Rule 3 talks about the cadre, and then Rule 5(1) talks about recruitment by way of promotion for the post of senior accounts assistant, which we are concerned about. And then, Your Lordship, Rule 11(2)(c) talks about the conditions, the eligibility, which is twofold, Your Lordship. One is that he has to successfully complete 5 years of service on the 1st of January and has to undergo training and must pass the departmental examination. And this has to be read together with Rule 12(1) and 2. Rule 12(1), Your Lordship, states that before the end of each year, the appropriate authority shall make an estimate of the vacancies to be filled by way of promotion in the next year. Therefore, Your Lordship, the vacancies of 2014 will be estimated in 2013. Similarly, Your Lordship, Rule 12(2) states that after this estimation, a list shall be furnished of who are eligible for promotion. This has to be read with 11(2)(c) for the year of estimation, Your Lordship. In the year of estimation, that is 2013, the writ petitioners have not completed the departmental examination. Therefore, Your Lordship, I have 2-3 judgments, Your Lordship, regarding this.
No,
regarding
that
whether-
is the problem. You see, you
Yes.
jump to the judgments. You must state the facts in a seriatim to support your contentions that these are your facts on the basis of which this is the law and these are the judgments in support of your
Yes, Your
contention. First, you're saying it is a calendar year, means it starts from 1st of January.
Yes.
So therefore, what you're saying is before the end of, these are vacancies of 2014.
Yes, Your Lord.
So therefore, the assessment will take before the end of the earlier year, which is 2013.
Yes.
So some vacancies, what is the position of vacancies that is not available in the records? How many posts were available on
Lordship,
that
that is
date?
in the minutes of the meeting, Your Lordship. 4 posts, Your Lordship.
4 posts were available.
Yes, Your Lord.
Now,
Lordship, page 142.
then the question of you say that how many people are eligible is to be decided by the authority.
Yes, Your Lord.
That we have already from the minutes that the minutes clearly reflect that these following 16 candidates fall within the zone of consideration, including the writ petitioner.
Yes, Your Lord.
So therefore, this is according to you, this is a step to be undertaken by the department.
Yes.
According to you, as per the rule, then this has been undertaken.
Yes, Your Lord. Lordship, rightly or wrongly, the petitioner's name have come up in the zone of consideration.
No, not rightly or wrongly. If you are urging, then you have to say that either the names have been correctly sent or wrongly sent.
Lordship, as per the department's submission last time, Your Lordship, Rule 12(1), which states that 4 times the number of vacancies, Your Lordship, assuming on that ground, they had placed 16 numbers, Your Lordship.
No. Exactly, 16 numbers.
Yes, Your Lordship.
So therefore, 16 numbers cannot be any name. It must be 16 numbers are within the zone of consideration, means they complete the requirement of number of years of service, and they also complete the pass the departmental examination and clear the examination. So these 16 people have completed all the requirements. So how do you say that these 16, how can you justify page number, come to page number 93? This is the minutes.
Internal page 63, Your Lordship.
Internal, I don't know what,
In
25
the
maybe.
rejoinder, Your Lordship,
Sorry?
submitted by the petitioner.
It is a continuation page of 93, continuous page of 93. Internal perhaps 25. Have you got it? It's the minutes.
Yes, sir.
It's the minutes.
Yes, Your Lordship.
So in the minutes, there is a, whichever page you want to take, second page it says, sorry, you're in the senior accountant.
Yes, Your
So
Lordship.
it says that which post is it?
Lordship, for promotion to senior
Senior
accountant.
accountant. Okay.
Resolution
Senior
3.
accountant will be resolution 3.
Yes, Your Lordship.
So this resolution 3 says the following candidates fall within this zone of consideration. This is a clear finding by the authority. The zone of consideration indicates that they satisfy all the requirement.
Your
Now the
Lordship.
question needs to be decided on the basis of seniority cum merit.
Lordship, on the last occasion, it was already admitted that the wrong criteria has been applied, Your Lordship, of merit cum seniority instead of seniority cum merit. What I'm trying to say, Your Lordship, that even if they're in the zone of consideration, there's no vested right to promotion. They can only be considered, and since they were in the zone
Exactly,
of
that
consideration, they were
consideration has to
considered.
be as per the rules. You
Lordship,
show
they
us
have
that
not
it was done as per
fulfilled
the
rules, Your
rules.
Lordship. They have not fulfilled the second condition in the rule.
That is your interpretation. You are interpreting this in the same lines the government is doing without producing the records. Are the records available?
Lordship, only the minutes have been annexed.
You show us the agenda note.
Agenda notice also not there,
Then?
Your Lordship. Okay, but I have in this regard, if I may submit a few judgments, Your Lordship, regarding whether promotion year should have been regarding promotion year and acquiring qualification in the same year, Your Lordship. There's a judgment of this honorable court, Your Lordship. Lordship, in this judgment, Your Lordship, that was regarding the ACRs of the petitioner for the promotion year, whether it should have been considered for the vacancies that arose in the promotion year, which was the same year, Your Lordship. If Your Lordship turns to internal page 9, Your Lordship.
Yes.
Lordship, paragraph 14. In the opinion of this court, the words 1st of January of the year of promotion reflected in the extract of notifications so and so would have to relate back to the vacancy year and not the actual year of promotion. Then there's an example also, Your Lordship.
No, where is the rule here?
Lordship, this is a different.
I know, but what is the rule in
Lordship,
this?
that is in paragraph 11, Your Lordship.
Yes, kindly read the rule.
Lordship, the relevant extract of notification dated so and so reads as under promotion up to the rank of superintendent engineer, merit and suitability with due regard to seniority.
This is not the criteria.
Lordship, the last line, ACS for the period of 5 years on the 1st of January of the year of promotion.
Yes. This is not.
It is not the exact criteria, but Lordship, what should be taken, your Lordship, in the sense?
No, in this judgment, this is the rule, so the interpretation will
Yes,
have
your
to be with regard to this rule. This
Lordship,
rule
in this-
says,
Yes,
this
your
rule says ACRs for a period of 5 years on 1st of January on the year of promotion.
Lordship, and ours is also 1st of January on the year of promotion, only because of the
What is
word
that
and.
1st of January of year of promotion?
Lordship, if your Lordship turns to paragraph 15 in page number 9,
Clear vacancies of 2016.
in the present case, the year of vacancies is 2016, and in terms of the rule of 1978, rules means a calendar year that is from 1st January to 31st December. Similar in our case, your Lordship, our year of vacancy is 2014, and we are also taking the English calendar year in terms of rule 2H. Therefore, in page 10, your Lordship, therefore, for a vacancy that occurred in the year 2016.
That is the point of controversy.
Yes, your Lordship.
If we accept that under the rules, this particular interpretation that you have to complete your examination also within the first of the beginning of the year, then they're out.
That is my submission, your Lordship. They'll be out because it will be considered in December 2013,
But
when
then,
the estimate is being
then
made,
if we
your Lordship.
accept that argument, then why are they put up for promotion as within the zone of consideration? How will they be in the zone of consideration? Zone of consideration require two things. Number one, years of service. Number two, clearing the examination, undergoing departmental training and clearing examination. So essentially three things. So unless you complete all the three, you are not within the zone of consideration.
Lordship, they had not completed actually, rightly or wrongly, your Lordship, the petitioners that.
You are not
they have-
challenging that.
Lordship, they have also not challenged the minute, your Lordship. They have only asked for notional benefits of promotion.
If the minutes are challenged, that means your promotion will have to be affected now.
Yeah, but your Lordship, if they're not even eligible, they're not, they cannot challenge the promotion also for which they were not eligible, your Lordship.
No, that is you are trying to interpret that, but you'll have to bring that interpretation. You'll have to show us by some reference that this interpretation, that your interpretation is the correct interpretation.
Lordship,
Which is why we wanted to see the agenda notes, which are not before the court.
Lordship, if I may, Lordship, on a similar line, I have two more judgments, your Lordship.
Please produce.
Yes, your Lordship. Lordship, 2018, 15 SCC 796, your Lordship. This is also about ACRs, but up to which date it has to be taken, your Lordship. This case also discusses the same, your Lordship. If your Lordship turns to page 9, your Lordship. Paragraph 3.2, third paragraph, your Lordship. This is based on the guidelines, your Lordship, in pursuance to RS Das versus Union of India. Lordship, in terms of the guidelines, your Lordship, 3.2, it states that the crucial date for preparation of the select list is 1st of January of the year of the select list. The ACRs up to the year of 31st March, where ACRs are written on a financial year basis, or 31st December, where ACRs are written on calendar year basis, of the year preceding the year of the select list are to be taken into consideration by the selection committee. Lordship, then if your Lordship turns to page 12, your Lordship. Paragraph 12.
You are reading which judgment?
Lordship, 2018-15 SCC.
No, say the name.
Lordship, Union Public Service Commission versus M. Satya.
Then paragraph.
Lordship, paragraph 3.2 in page 9, your Lordship. The page number is at the bottom of the page, your Lordship, on the right side.
Paragraph, page.
Page 9, your Lordship.
Nine.
Third paragraph, your Lordship, 3.2. These are from a guideline from your Lordship, based on the decision of RS Das versus Union of India. Lordship, paragraph 3.2, if I may read, your Lordship. As the crucial date for preparation of the select list is 1st January of the year of the select list, the ACRs up to the year ending 31st March, where ACRs are written on a financial year-wise basis, or 31st December, where ACRs are written on the calendar year-wise basis.
No quarrel.
This is in regard to ACI, your lordship, but it's discussing the same issue when it has to be read, your lordship. Therefore,
Then you show us the rule. Where is the rule which is being discussed here?
lordship, next page, your lordship. Lordship, this is discussing actually the crucial date.
You come to page number 4.
Yes, your lordship.
This is rule 5.
This is regarding IPS appointments, your lordship.
We know that.
Yes, your lordship.
So read the rule.
There cannot be any dispute that the UPSC discharges
No,
the
no, read
function.
the rule. Read the rule. Rule 5.
Each committee shall ordinarily meet every year and prepare a list of such members of the state police service as are held by them to be suitable for promotion to the
Yes,
service.
suitable for promotion.
Yes, your lordship.
So it's not just any officer. You must come within the zone
Yes, sir.
to be suitable for promotion. Being suitable does not necessarily mean you are promoted.
In my
Even,
humble-
even if you are included in the select list doesn't mean
You have to be.
you have a
selected,
right.
yes, yes, your lordship.
But you, not any officer will be included. You must be suitable for promotion. Then
The number of members of the state police service to be included in the list shall be determined by the central government in consultation with the state government concerned and shall not exceed the number of substantive vacancies as on the first day of January of the year in which the meeting is held in the post available for them under Rule 9 of the recruitment rules. The date and venue of the meeting of the committee to make the selections shall be determined by the commission. Lordship, then provided that no meeting of the committee shall be held and no list for the year in question shall be prepared when there are no substantive vacancies on the first day of January of the year in the post available for the meeting of the state police service under Rule 9 of the recruitment rules. Or B, the central government in consultation with the state government decides that no recruitment shall be made during the year to the substantive vacancies as on the first day of January of the year in the post available for the members of the state police service under Rule 9 of the recruitment rule.
now come to page number 5.
Yes, your lord.
Come to the 6th paragraph, proviso.
Provided also that the committee shall not consider the case of a member of the state police service unless on the first day of January of the year for which the select list is prepared, he is substantive in the state police service and has completed not less than 8 years of continuous service, whether
This
officiating.
is a very
sir.
explicit rule.
Yes, sir.
It provides that unless on the first day of the year,
Yes.
he has completed this and has held this post so and so, so and so.
But
This
in
is
our
the
case,
rule.
it is determined at the end of the previous year.
Correct.
Yes, sir.
But the rule says that
That he
while,
has-
while you are determining,
Yes, sir.
on that particular time you have to complete it.
Yes, sir.
Your rule doesn't say that. The reason, you see, the reason at the cost of repetition is because the agenda, the minutes itself says these are the officers who are taken into consideration. So what is the meaning of the term taken into consideration?
That is why, your lordship, in my humble submission, I am saying whether rightly or wrongly they have been included. But that does not give them a vested right to be promoted.
Certainly
They can
not.
only be considered, and they were considered and then they were rejected, your
No,
lordship.
no. They may be considered, but they'll have to be, you see, the authority, the committee will have to give a finding that notwithstanding they being put up for selection as selected candidates, their cases are wrongly put up because they did not complete. No such finding is there,
Yes. The only
which is
finding
why
that
we
they are not-
wanted to see the minutes.
Yes.
The minutes are not here.
Lordship, the minutes are there, the agenda
Sorry,
is
the
not.
agenda note is not here. Agenda note reflects who are the officers who have completed what and who have been put up. It's not here. So, left to itself, we'll have to take the literal meaning of this word that these fall in the zone of consideration. What is the meaning of zone of consideration?
That they have fulfilled the criteria. But that is why I'm submitting, a lordship, rightly or wrongly, they have been placed and then they have been considered and then after consideration they were rejected.
No, they cannot be, they cannot, once the authorities consider them, you see, I could have understood that these officers were not considered by the committee on the ground that they did not fulfill the required criteria. This was not done. They said, out of the so and so, so and so, so and so, these officers had not passed the departmental exam.
Lordship, in a situation as such, your lordship, I have another judgment. I don't have the citation, your lordship. It's the 1996 judgment of the Supreme Court by a division bench. I've already placed it, your lordship. A 4-page judgment, your lordship.
What is the name of the party?
Ramesh Kumar Soda versus State of MP. Date of judgment 20 September 1996, your lordship. It's a short judgment, your lordship. Lordship, in here.
See, there are ample lot of facilities offered at the bar, offered by the judges l'ibrary. You take out proper copies of the
Your lordship,
judgment.
I will submit a proper citation one, but your lordship,
When, after the case is over, you submit and rely on the judgment. Why these are available in the High Court? You type out the name and you can take out a proper copy. Yes, anyway, what are you
anyway, your
submitting
lordship,
here?
in page 3, your lordship,
Hmm.
if I may read, your lordship, the last paragraph. A resume of these rules, their rules, your lordship, regarding conditions of
So take us
eligibility.
through the rules first.
Yes, your
Let
lordship,
us
the
see.
first page, your lordship.
Yes. Condition of eligibility.
Yes, your lordship. First condition, subject to the provisions of sub-rule 2, the committee considered the committee considered the cases of all persons who on the first day of January of the year had completed the
Of that year means which year?
lordship, in this case, it's 1992, your lordship.
Which year? It is the year of the vacancies or the previous year of the vacancies?
Yes, your lordship.
Yes, what?
First day of that year, lordship, promotion year, your lordship. Year of promotion. First of January of that year had completed the prescribed years of service, whether officiating or substantive, on that post service mentioned in column 2 of Schedule 4 or any other post of Schedule 4 or any other post or post declared equivalent thereto by the government as under and are within the zone of consideration as per sub-rule 2. First condition, your lordship, sub-engineers, head draftsmen to the post of assistant engineers, minimum service of 12 years as sub-engineers, head draftsmen.
You show us if you have any judgment in support of your contention that it is the zone of consideration means what? Zone of consideration is to be satisfied unless prescribed under the rules specifically when? In the first year of that year or
Lordship, if I may insist on one more paragraph in this judgment, your lordship.
one minute. You come to rule 12.2. You read rule 12.2.
The appointing authority shall then furnish to the board the following documents and information with regard to as many incumbents in order of seniority equal to 4 times the number of vacancies as are eligible for promotion.
Then?
Information about the number of vacancies, list of incumbents in order of seniority eligible for promotion.
Exactly. Eligible for promotion.
Therefore, if we go back to rule 11 to see who are eligible, your lordship, 5 years as on 1st of January and undergone training and successfully completed. Lordship, if we do
Therefore,
not.
we are coming back to what
Yes,
we are
your lordship.
saying, that the minutes itself shows that these are the people who are fit for consideration.
But your lordship, the other 2 conditions will not be fulfilled, your lordship.
But that is not reflected in the minutes.
That is why they have been rejected, your lordship.
That is your intent, that is your contention. But unless we unless you show us from the records or available from the records, it is difficult to understand why. It is like presuming that the appointing authority overlooked this provision and submitted names of persons who were not eligible.
That is why, Your Lordship, I was trying to submit a judgment which I don't have the citation, Your Lordship, but it's.
You show us a judgment which defines what is a zone of consideration. What is the meaning of being eligible for consideration? What is the meaning of that? You show us any judgment on that. If you have, if you look for, you'll find judgment. Ordinarily, yes. What you're trying to urge is a possible argument, but that is dependent on the rules. The rules are very clear that you have to, these rules are amended subsequently.
Yes.
Where are the amended rules?
I have annexed with the writ petition.
Writ petition,
Yes, my lord. It was
Page
adopted
number?
on 25 and 14, page 34 and 35 of the writ.
34 and 35.
That rule has not been amended. The bottom of the list column has come.
So no other amendment after this.
Fine.
This is 2023, no, Your Lordship.
This is the 14th amendment.
Yes, Your.
No other amendment.
Lordship, at the cost of the court's valuable time, Your Lordship, I would like to, once we can just go back to that third judgment, Your Lordship. Because that is a similar case, Your Lordship, where work experience was there, but the qualification of graduation was acquired later, but before the DPC, and the qualification was acquired on the same year as the DPC was held, Your Lordship. Lordship, the last page, Your Lordship.
Of the coordinate bench,
Yes, Your Lordship, the 4-page judgment, Your Lordship, 1996, Your Lordship.
Supreme Court.
Yes, Your Lordship. Lordship,
Yes.
the first paragraph, Your Lordship, in that case, the case of the appellants is that though the respondents had completed the eligibility criteria as on January 1st of the year 1992, a fact that the graduate qualification acquired subsequent to that date, but before the DPC had considered their case, are not entitled to be promoted. The approach adopted by the tribunal is illegal and contrary to the Rule 15 and 16 of the rules referred to herein before. We find force in the contention. As seen, Rule 15 is a clear mandate as to the eligibility criteria. Firstly, the diploma holder should have minimum of 12 years of qualifying service for eligibility to be considered for promotion as assistant engineers. If a diploma holder acquires a graduation, he should complete minimum of the 8 years of service. Then only he becomes eligible for consideration for promotion as assistant engineer. He should hold the post as a sub-engineer in a substation or continuation officiating capacity as prescribed. But the cutoff date for eligibility is 1st January of the year in which the eligibility was to be considered. Since the respondents acquired the qualification in October 1992, they did not become eligible for consideration for promotion for the year 1992, though the DPC had met in 1992, which is a little similar to our case, Your Lordship, because in our case also the petitioner acquired the qualification.
You're not, see, you have to argue the matter on the basis of whatever is there in black and white. Your wish cannot be construed to be an argument or an interpretation. The interpretation must be drawn from materials which are capable of being taken cognizance of by the court. So here the interpretation which you are pointing out to suggest that in the present rule also similar interpretation is called for, is only because of this specific rule here, Rule 15. Rule 15 is very clear. On first day of January, must complete prescribed years of service in the so and so. So therefore, it is clear that on the first day of January, they have to complete. Now, in this case, had it been a case that they did not complete their years of service on the first day, then perhaps they are not eligible.
Regarding the additional graduate qualification which was required, either that is my submission. Your Lordship. Otherwise,
What does the rule say?
Lordship, Rule 15(1), sub-engineers, head draftsman to the post of assistant engineers, minimum service of 12 years as sub-engineers, head draftsman, provided that a sub-engineer, head draftsman who completed a minimum of 8 years service and possess degree in civil, electronic, mechanical engineering from recognized university or qualification declared equivalent thereto by the state government, will also be eligible for promotion to the post of assistant engineer and will be considered each time just after the zone of consideration, and the final select list shall be made from both the groups on the basis of merits. For example, if 10 posts are vacant in the cadre of assistant engineers, then 10 into
See, here the interpretation is required because 8 years was prescribed for graduation and
12 years.
12 years for sub-engineers.
Yes, Your
That
Lordship.
means those were not graduates.
Yes, Your Lordship.
So therefore, on the date when they were put up for consideration, whether they were graduates or not, whether they had completed 8 years for graduation or not.
Lordship, in the last page of the judgment, it
No,
has-
you see page number 3 of the judgment, last paragraph.
Yes, Your Lordship.
It is not in dispute.
It is not in dispute that the appellant as on January 1992 had not acquired the graduate qualification, but some of them had completed 8 years, which is similar to our case, had completed 5 years, but do not have the requisite.
No, you are extending that. That interpretation is not here. Had they not completed 5 years, we could have understood.
Similarly, the respondents who were promoted as per the
Okay,
direction.
anything else?
Lordship, may I take your lordship to the rules, my lord? Rule 12.
So have
my
you
lord.
seen the judgment which they've relied on?
But my submission is different, your lordship, because on the
But
date,
have you seen the judgment?
no, I have not.
Then you have to go through the judgment,
I'll go
whether
through
you'd like to submit anything on the judgments or not.
Yes, my lord, I'll go through it. In the meantime, your lordship, I have got certain judgments. When cutoff date is not mentioned, my lord, how the court will deal with it, my lord. Lordship, on the date when the post fell vacant, your lordship, what my learned friend has submitted. According to the, going into the minutes of the case, my lord, the post fell vacant, your lordship, lordship, may I take your lordship to page 25 of the affidavit in opposition? Yes, ma'am. And rule is clear, my lord. General procedure of promotion. My lord, before the end of each year, the appointing
No,
authority.
we have gone through the rule. We've
Yes.
gone through the rule. We have gone through we are only stuck at the interpretation.
Yes.
Whether this 5 years is
Yes.
to be included for experience as well as for departmental
My lord.
examination. That's
My
the point of dispute.
Yes.
That's the point of
Since the learned friend has submitted that there was no vacancy, there was vacancy, my lord, it was a vacancy of earlier year. My respectful submission is that there was no vacancy. The vacancy arose, that's why I have made submission to refer to page 25 of the affidavit in opposition, my lord. This vacancy has arose only on the date when this person's, my lord, serial number 1, 2, 3, 4, Jayanto Saha, have your lordship got it?
25.
Lordship, page 25.
This is the affidavit, okay, filed by the department.
Yes, my lord.
25. Yes, 25.
Yes, when the senior accounts of assistants, my lord, have been transferred to accountant. These 4 vacancies, my lord. That when it arose, it arose on first day of January, not on first day of January, but they were considered for promotion, this senior account officer to the post of accountant by way of the 2014 rules, 2014 order, my lord, my notes, my lord. So prior to that day, there was no vacancy. 10/10/2014, the promotion of this
So,
co-incumbent,
so these are vacancies of which year?
vacancies of, my lord, that has not been mentioned, my lord, but my respectful submission, this post fell vacant on the promotion of these 4 persons.
Correct, but
Yes.
it is still to be considered to be a vacancy of which year?
That is the
2014, your
department,
lordship.
department,
No.
because promotion, my lord, as per
If,
the rule,
see, going by your understanding, it will still be a vacancy of 2014.
No, my
Your
lord.
submission is
Yes,
that in 2013, there was no assessment of vacancies.
no, there was assessment because
Ah.
rule is clear. Before the end of each year, may I read it slowly?
Yes.
The appointing authority shall make an assessment, my lord. They will make only an assessment of the likely number of vacancies to be filled up by promotion in the next year each cadre. So my respectful submission is that since this purpose will fall vacant on a particular date, my lord, so they have given they have made assessment as regards number of vacancies will be fallen vacant on a particular date, my lord. So this assessment has been made, and since my like the persons along with my the present petitioner, they have crossed the zone of consideration of passing departmental examination, uh, completing 5 years as of 1st of January, my lord. So their cases were placed before the departmental promotion committee. They're not, the case of the respondent is not that I didn't acquire qualification of 5 years of lordship, 5 years of experience. But case of the respondent is that I did not pass the departmental examination. But the requirement is not there as per the rules, my lord. Requirement is only 5 years experience, passing departmental examination, and undergoing training. Since I have crossed 3 benchmarks, so my name was placed before the departmental promotion committee. And as such, but mere rejection on the ground that I did not qualify on the 1st of January 2014 is bad in law, my lord. That is their own interpretation. They should not have done. That is their own presumption and their own assessment, my
Yes.
lord.
You want to rely on some judgment?
Yes, ma'am. First judgment in 9710 SCC 419.
To what effect?
My lord, when the rule is silent, my lord, para 8 and 9,
97?
10 SCC 419. State of Rajasthan versus R. Dayal and others.
Paragraph?
Paragraph 8 and 9. Here there is some amendment rules, my lord, amended rules. The posts which fell vacant prior to the amendment of the rules would be governed by the original rules and not by the amended rules. As a necessary corollary, the vacancies that arose subsequent to the amendment of the rules are required to be filled up in accordance with the law existing as on the date when the vacancies arose. Even a carry forward vacancy is required to be considered in accordance with the law existing unless suitable relaxation is made by the government. So on the date when the vacancy arose, lordship, the cases should be considered. My limited understanding is that, Your Lordship.
When did the vacancies arise?
My respectful submission is the vacancy arose on the promotion of these 4 incumbents to the post of accountant.
When were they promoted?
Promoted the same date, my lord.
So therefore, on which date the vacancies arose?
My
So you
respectful
are saying
submission,
that
these are the dates, but because the promotion committee had made the assessment, these 4 posts will fail vacant, my lord.
Right.
My lord.
So either you say that the assessment was already made in 2013
Yes,
as per the rule,
yes.
or you say that there was no assessment made, but having these promotions, these posts having fallen vacant, they are filled up by the petitioners and the private respondents.
Petitioner
Which-
was not,
which-
petitioner did not fill up because my
private
question was
respondent.
rejected.
Private respondent.
My lord.
Which does not appear to be the case because there has to be some assessment made prior to, otherwise how your names were,
It's not clear from the affidavit filed
we
by.
presume it,
My lord.
how else your names were put up?
My lord,
unless the vacancies are known.
lordship,
There is a fixed number of names which are put up.
my lord.
The question which you are required to answer is that what is number one, the meaning of zone of being placed in the
Consideration.
zone of consideration? Does it mean merely because you satisfy the number from the seniority in terms of the seniority list?
My lord,
Or does it also include that you have to satisfy the norms, criteria or eligibility
my lord.
for being included in the zone of consideration? This is one. Secondly, that the rule itself says beginning of each year is applicable only for the years of experience, not for departmental examination. That is what you want to submit. Rule 11, Rule 12 or Rule 11. Rule 11.
Yes.
Is it Rule 11?
11 to C, my lord.
11 to C.
Yes, a junior account assistant who has completed at least 5 years of service, a junior account assistant on the 1st of January of the year of promotion and has successfully undergone a training and passed a departmental examination as may be prescribed under Rule 18.
So according to the department, both these conditions must be fulfilled on 1st of January, which you did not fulfill.
Yes, their case is that, my lord, but my case is that since I have fulfilled all the criteria, that's why my case was placed before the DPC for consideration. And the rejection of DPC on the ground that I did not pass the departmental examination on 1/1/2014 is bad in law, my lord.
Okay.
Lordship, one more judgment. Two thousand seven, 4 SCC 54, my lord.
Yes.
Here, as regards appointment, my lord, but our case is promotion. When the rule is silent, my lord, how the lordship will, how the court will interpret. Para 20, 15, and 11. Lordship,
Paragraph?
20, 15, and 11. I'll be just relying on reading out only few lines. Possession of requisite educational qualifications is mandatory. The same should not be uncertain. If an uncertainty is allowed to prevail, the employer would be flooded with applications of ineligible candidates. A cutoff date for the purpose of determining the eligibility of the candidates concerned must therefore be fixed in the absence of any rule or any specific date having it fixed in the advertisement. Here there was an advertisement, my lord, in the instant case. The law therefore be held by the Supreme Court would be the last date of filling up the application. So in absence of any cutoff date, my lord, and any non-mention in
What is the last date of application?
here, it's not there, my lord.
No, it has to be interpreted to be 1st of January. Last date of application means the
Yes.
last date of eligibility. So your eligibility as per the rule will be assessed on the first day of the year of the vacancy. That is what the rule says.
But here, your lordship, rule is clear, my lord, because
No, you are referring to the
yes,
judgment.
my lord,
Therefore, I am
it
saying,
might go against me, but I'll be referring.
if it goes against you, why are you placing the judgment?
Lordship, one more judgment, my lord.
You are placing judgments against you. Yes.
It relates to the appointment part, my lord, advertisement. Here, in our case, is promotion, my lord. And rule is, my responsible submission rule is clear.
Yes.
1st of January, the date of passing the examination is not there, and date of undergoing training is not there. Rule is silent. Yes, it's
And if I may.
2002, 3 SCC 722, my lord. Section 7, 8, 9, and 16, my lord. Interpretation.
7, 8, 9, and 16.
Yes.
Yes.
And seven, clearly the language of subsection 7 of section 6 above said is plain and simple. There are two manners of reading the provision. Read positively, it confers a right on a returning member to seek re-nomination. Read in a negative manner, the provision speaks of a returning member not being eligible for renomination for more than one term. The spell of ineligibility is cast on renomination of a member who is retiring. The event determinative of eligibility or ineligibility is renomination, and a person by reference to whom it is to be read is a retiring member. Retiring member is to be read in contradiction with a member person retired sometime in the past and so would be called a retired or former member. Re means again and is freely used as a prefix. It gives color of again to the verb with which it is placed. Renomination is an act or process of being nominated again. Any person who had held office or member sometime in the past, if being nominated now, cannot be described as being again nominated. It is only member just retiring who can be called being again nominated or renominated. No other meaning can be assigned except by the doing violence to the language employed. The legislature does not waste its words. Ordinarily, grammatical and full meaning is to be assigned to the words used while interpreting a provision to honor the rule. The legislature chooses appropriate words to express what it intends and therefore must be attributed with such intention as is conveyed by the words employed, so long as this does not result in absurdity or anomaly or unless material, intrinsic or external is available to permit a departure from the rule. The provision is cast in the present tense. A retiring member is ineligible for promotion, not more than, Lasha, I'll be skipping those parts. Cross in statutory interpretation. The governing idea here is that if a statutory provision is intelligible in the context of ordinary language, it ought without more to be interpreted in accordance with the meaning of an ordinary speaker of the language would ascribe to it as its obvious meaning unless there is sufficient reason for different interpretation.
Okay.
My lord,
Yes.
I don't have to read it further.
Interpretation
Yes,
is
my lord.
okay. There is no, we are trying to find out the requirement. Let us see what happens. We
Right.
thought we'll dispose it of in court, but may require a second look. Yes, you wanted to submit something?
Lordship, regarding the interpretation, Your Lordship, I just want to submit that if we take it disjunctively, Your Lordship, then it will create
What is a
several.
disjunctive view?
Lordship, taking and as any other way as it is meant, Your Lordship, because these are.
Why should we?
That is what I'm submitting. If we take it, it will create several other options.
Hmm?
It will create several other options for someone who has 5 years of experience without undergoing training, or someone who is undergoing training but without 5 years of experience. It will open the avenues for any and everyone
Then
to
how do you
apply.
explain the zone of consideration?
That is that regarding that I've submitted in the sense rightly or wrongly, Your Lordship. Their name is there in the list, which is admitted, Your Lordship. They have a vested right to be considered. They do not have a vested right for promotion, but only to be considered for promotion, and they were
No, they have
considered.
they have a right to be considered fairly
Yes, Your Lordship, and they were
as per the
considered
rules.
even if their rule, even if their name came up.
Hmm? How can, see, even if their name came up and they are rejected, that is where the grievance is. Had the minutes been clear that no, this is not the interpretation required to be done, but so and so is the interpretation required to be given, then it's a different issue. Okay, heard, disposed. We'll reserve it. We'll have to dictate a judgment. Reserve it.